are remanded back, my lord. And husband's case is remanded back, and now the wife, my lord. So, my lord, a similar order may be passed, my lord. On next week, any date, my lord.
When the husband case was remanded, what the wife was doing? Was we separated, judicially
same-
separated? Then they were not staying together.
No, my lord.
On the same night, the husband must have talked, or the wife and husband don't talk or converse or what? You are coming after how many days? Your husband was referred when?
Referred, my lord.
When remanded when?
Remanded, my lord.
When,
1 month,
which time?
1 month.
1 month ago. And the husband did not disclose to his wife.
Case was not listed.
Huh?
Case was not listed.
What case was listed? No.
Any date in the next week. Humble prayer, man.
And the husband wants the wife to be declared a foreigner, then, then he will have another opportunity.
Let the matter come up, Lordship will examine it then. Let it come up first.
Okay. Next week. Yes.
Daily list for motion item 1.
Sukhron Nesa LCR is there. What do you want? Tell us.
My lord, in this regard, my lord, the petitioner directly registered their name, my lord.
Huh?
In 2001-96 and 225-371 in this period, my lord. So what happened, my lord, when the history was taken by the petition number 1 husband, and he was expired 1994, and other was the family member, my lord. My humble prayer, my lord, the petitioner directly to register.
No,
Only, my
Lordship,
lord. And the
this
similar
matter
order
is
passed,
hearing.
Lordship,
The last
order.
case also, Lordship,
My
the
lord,
records are here. It will kindly
number
look
of
into
cases,
the
my lord,
records.
this honorable court passed the order, my lord. My lord.
You have been declared a foreigner during that period?
Yes,
60 to 71.
yes, my lord.
Then after that, what happened?
My lord, actually, at that time, with the minor, my lord.
You were the minor?
Yes, my lord. We are the one, only my husband, my mother, the wife of the petitioner, my lord, others, mothers and petition number 2 to 7 are the sons and daughter of the petition number 1, my lord. And my husband or my father was step all the proceeding, my lord, in 2002, my lord. And subsequently, and expert was made, my lord. And father was expert, my lord, 28/6/1994, my lord. So we are not aware of-
Ex parte order
Yes, my
declaring you to be a foreigner of that stream.
Yes, my lord.
Hmm.
Well, kindly similar space.
See, Verma, if it is ex parte, therefore they would not know.
It is not ex parte. The
My
petitioner.
lord, order
appeared,
see, my lord.
Lordship.
Kindly order
The
see.
petitioner
38
appeared,
pages.
the LCR shows petitioner appeared, Lordship, after husband's death on 12/9/1994.
Huh.
And he says they never appeared, they were not aware of it. It is not true,
My
Lordship.
son.
No, Lordship, it is not.
Kindly
The
see, my lord.
wife appeared, Lordship. I have gone through the records and made a short note also.
Mhm.
The relevant pages of the LCR, if Lordship would like to look into
And
it,
kindly see
Lordship.
the order sheet, my lord. Page 38 and
And
13.
they even filed the WS, Lordship.
And in the WS, what did they say?
Lordship, and records of
Quran?
it was filed
What
on
did the-
31/1992.
Abdul Rashid.
Yes, my lord.
Initially, it was again Abdul Rashid.
Yes, my lord. And on the sons and wives.
Sons and wives.
Yes, my lord. And mother also. Abdul Rashid mothers also. My mothers and Abdul Rashid already expired, my lord.
OPs are found to be foreigners. Reading the record of the case, OPs are found to be.
Lordship, the relevant pages of
On
the
receipt of the
LCR.
reference, ASP Nagaon case is daily registered. This is OP file. Thereafter, OPs remain absent without any step. Hence, the case taken up for ex parte hearing. Gone through the written statement, OPs could not produce document that they came before one. Hence, OPs are helping foreigners of 1966-71. OPs are directed to register the names. Then MD Abdul Rashid, he produced Lane Khatia receipt, 1985. Named the other members' parent Lal Banu, wife Shukur Nehar.
That
Children.
one is my grandmother, my lord.
Hmm.
And
Then in the so you are challenging the opinion of the tribunal
yes, my lord.
in this
Challenge, but I allowed to restitution, my lord.
just a minute. So when did you appear like in
My lord, I appeared my written in 1991. Written statement
at
submitted.
that time the father was there when
Yes,
he was
my lord.
alive.
Yes, my lord.
Father
94
passed
years
on
expired.
94, Lordship.
94 expired. And order was passed 2020.
Correct. The father was taking all the, responsibility, no? The father expired on
28, 6,
1994.
1994. And when this opinion was passed?
2000, my lord.
After
21
2000. So the after father died, so they also didn't know.
No, Lordship, they appeared, Lordship. When you
Who
go to the
appeared?
LCRs,
Who
Lordship-
appeared when?
the petitioner, Shukuran Nesa appeared after her husband's death on 12/9/1994. She has appeared, Lordship.
Correct, 94, but then ex parte order was passed. No, after that they failed to appear.
But they
Ma'am,
knew
they
about
might-
but they knew about the proceeding. It is
Correct.
not that they were not aware of the proceeding,
That,
Lordship.
that you are correct.
They are
They're knowing about the proceeding. It is not that they did not know.
Yes.
But
they-
what kind of order was passed, they did not know. But
Yes,
they did not
yes.
know. They were aware of the
and-
proceeding.
and They are sitting on this for the last so many years. Our order was passed when Lordship will look into the impugned order in 2000.
Correct.
And today is 2022, Lordship.
Hmm.
My lord, in this
Lordship,
course, my
can
lord,
so much
95
alleviation
orders
be
also
given,
I
Lordship.
place your lordship, my lord.
Lordship, these excuses are just not
90,
acceptable, Lordship.
1990, 1995, I have placed your lordship in the coordinate best.
And they cannot say that they're not aware of the proceeding.
One is, my lord, Dhirendra Vishwas, my lord.
Within 60 days, Lordship, how many 60 days have gone? Do they know
That
this?
was, my
Lordship?
lord, in 1990, my lord, procedure.
And why now, Lordship, if they haven't registered in so many years, why do they want to register now, Lordship? And that too on the basis of an order passed in 2000.
In Dhirendra Vishwas, my lord, WBC number 4461, it was, my lord, so much 5 on 1994. Such kind of order was passed, and this honorable court passed and directed, my lord, as per the
And they have been casting their vote all since then, Lordship.
Why did you give a copy of this order? This,
Yes, you told, yeah.
4461, 2019. The copy of that. Can dispose of by what we can do. The point taking in this. The Verma
Yes,
in
Lordship.
the coroner's tribunal now passed the order on 5/1/1994 in that case also. For this, no? This is the decision of this court.
Lordship is not audible.
4, not audible. Oh. Sorry, okay. This case 4461 2018, Dhirendra Vishwas, no?
Yes, my lord.
So there the tribunal passed the opinion on 5/1/94, then they approved sometime in 2000. Later on, the father also died. They were not aware the necessity to register names. So they approached this court later on, 2018,
18, my lord.
94 opinion. So, learned tribunal case judgment. In another case also, this Loba Das and another, FT was opinion was 1990 and they approached in 2018. These things happen. These things are happening. Because under this
They
reason.
have been casting their vote also, Lordship.
Ah,
They've been casting their vote also on their instructions are there.
correct. See, they're casting it for there is a more, but then Verma, don't say that. It is against you.
No, it is against me. That
You, because
But
you
now-
allowing a person who have been declared to foreigner to cast vote,
Lordship,
that means you are tacitly agreeing that they are Indians.
Lordship, that this court had sought for instructions also.
Anyway-
despite being
Anyway,
declared
these
for-
two orders passed by this court, where also they had come very late. I think we will dispose of this petition. Han, Mister?
Lordship would observe that they did appear, but
Correct, correct,
Yes,
correct. Yes,
they,
yes,
they knew about the proceedings
yes.
all through
yes,
Lordship.
yes. Han, Mister, Learned Counsel for you, Han also Learned Counsel for the state. In this petitioners, namely so and so 1, 2, 3, 4. How many petitioners? 1, 2, 3, 4?
7, my lord.
7.
Yes, my lord. One is mother, other is sons and daughter. Family member.
In this petition, the petition number 7 petitioners have approached this court for a direction to the responsible authorities to allow them to register in terms of the opinion rendered by the Learned Foreigners Tribunal in where is the Foreigners Tribunal page number?
Page number 38, my lord.
Foreigners Tribunal dated 21/2/2000 passed by the FT number.
31.
Foreigners Tribunal Nagaon, Assam in FT case number 3125. The said opinion was rendered ex parte as the proceedings failed to appear after initial appearance, failed to appear in subsequent dates fixed by the tribunal after initial appearance and filing of written statement. The Learned Tribunal, after going through the written statement submitted by the proceedings, took the view that as they could not produce any document, that they came to Assam before 1196, declared them to be foreigners of the stream 11/1966 to 25/97. And the Learned Tribunal also directed the office to register themselves, register themselves with the company authority within 60 days from the day. Next paragraph. It is the case of the petitioners that the petitioner's father, that Mr. Abdul Rashid, the husband of the petitioner number 1,
Yes, my lord.
and father of the remaining petitioners, was pursuing the matter, and as such, and they were not fully aware of the consequences of the proceeding. Unfortunately, the father expired in the year 2000.
1994.
94, my lord.
1994. Though the petitioners thereafter appeared before a tribunal, could not continue to appear after the death of the said Abdul Rashid, leading to the passing of the said ex parte order. They have been submitted that though they were aware of the proceeding initiated against them, but they were not aware of the ex parte order passed on 21/2/2022. Neither they were aware of the implications of the non-registration. Full stop. Now they have realized that because of that, as they have failed to register themselves, they would be liable to be deported from this country in as much as they have been already declared to be foreigners, though entering India within the aforesaid stream. Next paragraph. Ms. Verma, however, has registered these petitions by stating that it is known that they were not aware of the proceeding, and as such, being aware of the proceeding, they were negligent in coming to this court at this belated stage. In as much as the opinion was rendered in 2000, but they have filed this petition in 2022, and as such, this petition deserves to be dismissed. In response to the said submission advanced by Ms. Verma, Mr. Learned Counsel for the petition has relied on a couple of decisions rendered by this court, wherein this court, even after declaration of the opinion by the tribunal that the proceeding had entered Assam within 1/1/1966, 25/3/1971, they were allowed to register themselves with the company authority at a belated stage. Referring to the decision, in rendered by this court in WPC number 4647 of 2018, disposed of on 23/7/2018, it has been submitted that from the order, it is evident that the petitioners therein were declared to be foreigners foreigners of 1/1/1966 to 25/3/1970 stream by order dated 15/11/1990 passed by the Foreigners Tribunal. However, in spite of the delay in approaching this court by filing the writ petition 2018, this court, considering the earlier order passed by the court in Pronuti Bala Sarkar versus and three others versus State of Assam and three others, WPC number 2295/2013, decided on 11/9/2017, was inclined to allow the petitioners to register themselves even at a belated stage. Full stop. Next paragraph. Learned Counsel for the petitioner also referred to the decision of this court in WPC number 4461/2018, in which the petitioners were allowed to register themselves with a competent authority in spite of approaching the court at a belated stage. In that case, the Foreigners Tribunal Nagaon passed the opinion on 5/1/1994 in FT case number 4124/1998, declaring the petitioners therein to be foreigners who had entered Assam during the period of 1/1/1966 to 25/3/1970. However, this court, relying on the decision of Pronuti Bala Sarkar, Supra, as well as Lobodas Supra, allowed the petitioners to register themselves with the concerned foreigners regional registration officer. Full stop. Having heard the learned counsel for the parties and also perused records, and also in view of the decision by this court on earlier occasions allowing registration even at a belated stage, we are inclined to allow this petition. Also, accordingly, we direct that the petitioners shall appear before the
Foreigner Regional Registration Officer, Hojai Melo.
Hojai to get register themselves, register in terms of the order dated 21/2/2000 passed by the Learned Foreigners Tribunal Nagaon Assam in the FT case number 3125/20 by relaxing the time period page above. Full stop. With the above observation direction, the petition is disposed of. The petitions will appear before the time. When?
2 weeks, 3 weeks.
Within?
2 weeks.
Yes,
Within 2 weeks, he said.
2 weeks. Go 2 weeks. Yes.
Lordship may, the last paragraph of where Lordship has been reading, Lordship would just observe Lordship, it is made clear that the petitioners, if do not approach the FFRO within the period above, they shall be liable to be apprehended, Lordship.
Okay. It also made clear that if the petitioners fail to appear before the FFRO within the 15 days, 15 days or 3
Yes,
weeks,
ma'am.
what? Huh?
Lordship, make it 3 weeks.
3 weeks. 3 weeks, huh? They will be liable to be apprehended by the authority and be deported from this country.
Lordship, and one more line. It is also made clear that consequent upon such registration, the petitioner shall not be allowed to cast a vote for the next.
But that is a law. No,
Lordship would.
okay,
Observe it,
consider.
Lordship. Why
Okay,
should-
oh,
My
okay,
submission
madam.
would also
Okay,
be
madam.
the Lordship.
Okay, madam. Yes, Ms. Verma also submits that. It may be also observed, as has been observed in the earlier orders, that consequent upon if they register themselves, necessary consequences will flow in as much as they shall not be allowed to
Cast their
Cast their
vote for the
vote
next 10 years
for next 10 years
from the date of registration.
from the date of registration.
Obliged, Lordship.
Well, you may be losing a vote also. Huh?
Losing or gaining, Lordship, we do not know.
Hello, Blush.
Next,
Item number 2 for motion.
Akbar. What is this? Motion. Press case.
Yes, Lordship.
Lordship.
What is the problem?
Page 88, Lordship, the impugned opinion, Lordship, and relevant portion is page 94, Lordship.
What is wrong
While,
with that?
Lordship, the learned tribunal did not consider his Lordship exhibits, Lordship. It is not the case, Lordship, he could not prove his citizenship. Only, Lordship, may I read, Lordship? OP was cross-examined at length. OP stated in the WS and admitted in the cross that his name is not Akbar Hussain. He further stated that he has no objection if this tribunal declare Akbar Hussain a foreigner. He stated that his name is Akbar Ali Mazumdar. OP further stated that in the year 2003, OP came to know that his name wrongly recorded as Akbar Wahid in the 1997 voter list. OP further stated that OP submitted a Form 6 before ERO Kadiwala as Akbar Ali Mazumdar. Learned AG submitted Form 6.
I
is
think
not-
this will require examination.
Examination law.
Okay.
Only on
Notice
that point
record
he
interim.
declared.
Huh?
Only on that point he declared for him.
Notice record interim.
Item number 3.
My lord,
Nurul,
my lord, I'm extremely sorry, my lord, the earlier the petitioner Nagav, so I written in Hosai, so Hosai only typing mistake, Hosai, my lord, that can kindly allowed to by hand, my lord.
people are Hojai.
Hosai, yes, my lord.
Oh,
He said Hojai only.
Oh, Hosai only, my lord.
but in the petition it is mentioned Nagaon.
No, my lord.
You said
SP.
Hojai.
Yes, he said.
Yes,
You said Hojai.
yes, my lord.
You went on, so you got confused with yourself. You should
said
record
Hojai.
your statement, carry a tape recorder. What did you submit? Then you come. You said Hojai.
Yes,
We have
my
also
lord.
said Hojai. Why you are
Hosai, but SP written, my lord, it was written earlier Nagav, so.
earlier
only-
where?
Earlier Nagav, my lord. So it is present Hosai, but only Nagav part, my lord. It will be Hosai, my lord. Only simple word, my lord. District part, my lord.
Oh, we are not concerned with the SP now. That is over.
Oh, hello, my lord.
FI
Now
PRO.
the FRO, you have to register us with the FRO.
Yes, my lord. That part right, man.
Oh, don't confuse anymore. No. If you have any problem, you come later on, file an application. Don't confuse.
IA later on.
You can file an IL. We have passed the order.
Hello,
You register yourself with FRO Hojai.
yes, my lord.
Finish?
Yes, my lord.
Yes, madam. What is this? Nurul Islam.
My lordship.
What happened to you?
My
Nurul?
lordship, this is a contested matter, my lordship.
Hmm.
Due to the change in constituency, my lordship.
Any
that-
constituency.
My lordship, that's
You
why,
change the constituency.
no, my lordship. Due to the change in constituency, in 1979 voter list, my lordship, the linkage could not be established between the petitioner and the parents.
So you
of the
shifted
petitioner.
from one village to another village.
My lordship, that's why.
Because you wanted to vote for another candidate.
No, my lordship,
Then-
village was same, my lord.
Huh? Village
But
is
the
same.
part.
Oh,
number was
village is
different.
same. You will examine then.
My
Notice
lordship.
record interim.
In the meantime, record may be called.
Yes, we will call the record also. In the meantime, anything else you want? In the
No, my
meantime,
lordship.
you don't want no bail also.
Interim bail,
Huh?
interim bail, my lord.
You want also that bail.
My lordship.
Okay.
Deeply obliged, my lord.
Item number 4.
Malika Banu.
My lord, the petitioner is a 71 years lady, my lord. She is presently bedridden, my lord. My lord, she declared foreigner, my lord, as my lord, he wrongly pronounced her mother's name, my lord.
Huh?
Her
You
mother's-
don't know your mother's
No, my
name.
lord, I know my mother name. The name appeared in the voter list along with my father, my lord. That was my stepmother, my lord. When in the process,
How many stepmother you have?
I have total my 3 mothers.
Examine lordship.
You have 3 mothers. You know who is the real mother then?
Yes, ma'am.
You will get confused again and again. If you are asked, every time you will say 3 mothers.
About 5-9.
Yes, what to do with 3 mothers case?
Examine
Notice.
lordship.
Okay, notice
At
record.
this stage, let notice go.
Notice, yes.
My lord, interim maybe one.
Okay.
Nice.
Item number 5.
5, 5.
Yes, what do you
Yes,
want?
there is a lordship.
Jamila Khatun,
Lordship, it's an ex parte order. or-
ex party.
Yes.
Why?
Lordship, I appeared, notice was issued on 24/1/22. And thereafter, next date was fixed for appearance and on 21/2/22, I appeared Lordship. I said I need time to file the written statement because of the documents. Later on 2/3/22, tribunal said that I have to file it within the 10 days. So they have ordered me to file written statement and evidence on the next day. That is on 14/3. I have clearly stated in my petition that even in the order, it reflects that I have written that I have, I want some documents and which I have applied also, and which I can prove also that I had applied lordship in this case itself. Lordship, when we will see the certified copy of the voters list, and on 4/4/22, she is declared Indian, foreigner lordship. And the voters list is at page number 25, lordship 24. If we will see that in that copied by 14/3/22, it's written lordship. I had applied, I have not wrongly stated in my petition also, Lordship.
Lordship, this reference has been pending since 2008. 31/3/2008, it's mentioned in the opinion, and almost 14 years, they have been seeking time to
No,
put this
14
document.
years, I have not received notice, Lordship.
So
Even
Lordship,
if we
When did
see
you
the
receive the
furnace order
notice? When
also.
did you receive the notice?
Lordship,
you-
I have received the notice on 21/2/22 for the appearance for the
Oh.
first time, Lordship.
Oh,
And Lordship, we will go for the 60 days things also, Lordship. Here in the furnace tribunal order, it's 14.14, Lordship. Section 3.14, here it's written, from the date of receipt of the reference, the case should be disposed of. So then it should be disposed of prior to 14 years back, Lordship.
okay.
Lordship may remand it back for fresh consideration
Yes.
and even observation that the petitioner would expedite with the written
Yes, sir.
statement.
Okay. Jamila,
Yes, sir.
Jamila Khatun.
Yes.
And Miss Learned Council, Betala. Learned Council, also Lance Ensure. In this petition, the petitioner challenged the opinion dated 4/4/2022, which was passed ex parte against the petitioner on her failure to file the written statement along with documents. It has been submitted that it is not a case that the petitioner has failed to appear or was negligent in prosecuting her case. In her case, she was applying for relevant documents, certified copies of relevant documents, which was taking time. And fortunately, she could not get the certified copies of documents within the time fixed by the Learned Tribunal. It has been submitted that if the Learned Tribunal does not consider her claim based on the documents which have been now obtained, she will suffer great prejudice. In MHS, she will be declared foreigner, as has been done in the present case. It has been submitted that under the circumstances, she may be given an opportunity to file the relevant documents to prove that she is an Indian, not a foreigner. Next, Ms. Verma also has very fairly submitted that if that is the case, perhaps she may be given another opportunity. We appreciate her stand in MHS in a matter relating to this opinion determining the citizenship of a person, unless the petition is hopelessly negligent in pursuing the case. It does not appear to be so in the present case. We have the view that she may be given another opportunity to appear and file the written statement and documents to prove that she is Indian, not a foreigner. And the circumstance, we allow this petition by setting aside in June order dated so-and-so, passed by the Learned Foreign Tribunal so-and-so. The petitioner will appear for the foreigner within a period of
1 month. Lordship.
1 month from today and file the written statement without fail.
Yes,
Written statement and documents without fail. And the Learned Tribunal will proceed with the matter in accordance with law and with law. It also made clear, made clear that during the pendency of the proceeding, the petitioner may be allowed to remain on bail, however, subject to furnishing a bail bond of rupees so-and-so. SP border,
No, Moricom, Lordship.
Moregaon. Mobile number, you have got mobile number,
Yes, Lordship.
personal mobile number,
Yes, sir.
personal mobile number.
No problem.
Item number 6.
Sabir Ali,
Maybe solution. The case is pending before the Learned Tribunal number 4.
Mhm.
In this case, my lord, the petitioner appeared in the case, filed WS and evidence. And thereafter, last evidence was filed on 16/11/2021. Thereafter, the case was fixed on 4/1/22 for cross-examination. On that day, the petitioner was suffering from ailment and therefore could not appear before the court. Then the case was fixed on 15/2/2022 for cross-examination of the witnesses. On that day, all the witnesses were appeared before the Learned Tribunal for facing cross-examination, but the Learned Tribunal was not was in leave manner. Therefore, the cross-examination could not be done. Thereafter, on 4 occasions, my lord, the petitioner failed to appear before the Learned Tribunal for his ailment for facing cross-examination. And the medical document also annexed by the learned advocate in with petition for second time, my lord. But on last occasion, that learned advocate has filed the petition that he could not communicate the date fixed to the petitioner, and therefore the petitioner failed to appear before the learned tribunal. However, the case, the evidence part is closed by the impugned order, and the case is for final.
You don't have a phone number, mobile phone number.
No, my lord. My lord, mobile has been, my lord, damaged last year.
Damage.
Yes, my lord.
How?
It is not, my lord, it become inoperative, my lord.
You buy a new mobile phone. You-
That may be, my lord, but he is very poor person, and therefore he could not manage money.
Whether you are poor or not, if you want to defend your citizenship, you buy a mobile phone. Take a loan from anybody from your Gram Panchayat or bank or whatever it is.
All right, my lord.
But don't ask from your wife.
2018 reference lordship.
Huh?
This reference is of 2018. And on the last, within a year, he has taken about 10 adjournments to file.
He say he also not well.
But
He
he
not.
is testing the patience of the member also now. This cannot be allowed all the time.
Lordship, one, my
Yeah.
lord,
Lordship, this,
15 to
How old are you? How old are you?
he's just
58 years.
58.
And what kind of illness you are suffering from?
Heart disease is there, my lord.
Heart disease.
Yes.
Where is that document?
Document, my lord, he has,
You say that you have medical document. Why is there so any medical document you are suffering from heart disease?
it should be test was done, my lord, annexed
1 year to buy 1 year, he takes to file one document, lordship. From 2018
And
till
accept
today, he's been seeking time.
So what do you want now? Tell us.
My lord, I may be allowed to face cross-examination, and thereafter the case may be
Cross-examination of the witnesses.
witnesses, my lord. Only one chance, my lord.
Document-
It is not the
cross-examination-
case that I willfully avoided. I was
He will
present
provide
before the
his
learned tribunal.
number- he'll provide
Mobile
his
also, mobile
also.
number, go and buy a new mobile number.
All right, my lord. I will suggest.
But we tell you again, don't ask your wife to do that. Don't put your,
For
you earn your, huh?
for cross-examination from 16/11/21, he has sought 9.
Not 1611, my lord. On
Cross-examination of which witness?
16,
himself.
All the witnesses.
Huh?
All the witnesses.
So you tell all the witnesses to come also. Huh? He's also, otherwise we'll.
Lordship will fix up a time within this much
Within
time,
what?
he has to finish
Yes.
with his. procedure,
Next date
lordship.
is fixed on 5/1/2022.
5-1,
22. Sorry, 23. It would be
5-1, January.
5 years ago.
You present, they will, then will not adjourn, we'll say on 25-1, let them be present for
For
cross-examination.
cross-examination.
Okay.
And that would be the last chance. He cannot seek more adjournment.
Don't
or
fall
time
ill,
after that.
don't fall ill on that day. You
We
take care of
cannot
your,
take the tribunal for granted like this, lordship.
don't, you careful not to fall ill. Of course, yes, that of course, I mean, she has to be present. At least let him start the process because process may continue for some time also, no?
Sometime
That is for the tribunal to decide. We will not say anything. But on 5/1/23, you must be there.
Yes.
Even if it may be a cold, biting winter. 5-1 January is very cold.
No, lordship, as we don't suffer that winter of Delhi of the north.
Okay. Which
It's
is
very
this place?
comfortable here.
Which is this place?
This is,
Gwalpara, my lord.
this is
Walpara is not
Walpara.
very cold.
We can manage.
Okay. In this petition, the petitioner has challenged the order dated. What is the order page number?
Page number is my lord 64, my lord.
Last page,
Type
lordship.
copy and particular is 60.
17/10/2022, passed by the learned tribunal, by which the learned tribunal, because of absence of the witnesses, witnesses on as many as 1, 2, 3, 4, 5, 6, 7, 8, 7, 1, 2, 3, 4, 5, 6, 7, 7 occasions, declined to adjourn the matter and fix and close the examination and close the evidence and fix the matter for argument on 28/11/2022. it has been submitted by Lane Council for the petitioner that it is not the case that the petitioner is negligent, but because of his ill health and also lack of communication with his counsel, on the above occasions, he could not appear, though he had been appearing, had filed his written statement and also adduced evidence. Unfortunately, on the aforesaid dates fixed for cross-examination, the petitioner could not, the petitioner and his witnesses could not be present. They have been submitted that was because of circumstance beyond his control, and praised that he may be given opportunity to appear before a tribunal and produce the witnesses for cross-examination, as otherwise without cross-examination the evidentiary value of the evidentiary value of the deposition of his deposition as well as witnesses and the documents filed will be rendered odious. Under full stop. Ms. Verma has submitted that the order itself would indicate that the petitioner was absent on as many 7 occasions, which shows that he has not been pursuing the proceeding diligently, and such delay on the part of the proceeding cannot be appreciated. Full stop. Next, we also have the view that the proceeding cannot be allowed to remain absent for so many occasions, as it would ultimately defeat the purpose of the proceeding, as these opinions is required to be given by the tribunal within a time-bound period. Full stop. However, considering the documents, after hearing the party concerned document which have been referred to, we have the view that the petitioner may be given a last opportunity to appear before the tribunal, so that the course examination of the witnesses can be conducted, and accordingly we allow this petition by setting aside the order dated 17/10/2022, closing the cross examination and fixing the matter for argument. So from next, it has been submitted, the case has been fixed on 5/1/2023 for further proceeding, for hearing, for argument, for argument. If that is so, let the petitioner and his witnesses be present on that day, so that necessary cross examination can be conducted, and thereafter the tribunal that was conducted for the tribunal, after cross-examining the proceeding and the witnesses that may be produced on that day or subsequent dates as may be fixed by the tribunal, will proceed with the matter. With the above observation, direction present instance allowed. Let the petitioner allow. So it also made clear that if the petitioner fails to appear before the tribunal on 5/1/2023 for the purpose of cross-examination, the tribunal will liberty to proceed with the matter at the stage of argument and pass the appropriate opinion.
Item number 7.
Sahida,
May I finish the law?
yes.
Contested case, my lord, page 55 is the impugned order.
What is wrong with that? Tell us.
Wrong, my lord, everything is there, my lord. Linkage is there, 1966, 1971, every voter list is there. But tribunal finds that linkage is not established. Although, my lord, the voter list can readily suppose that my linkage is with my
Will
father and
examine
grandfather.
Yes, Lord.
notice record enter. Yes, next.
Oblige.
Item 8.
Sabdullah.
Yeah, petitioner, his elder brother examined. But brother, it is not considered because interstate witness.
Interest.
Because interstate.
Madam Lordship.
Notice record interim.
Item number 9.
Yes, madam.
Elder brother examine lordship.
Elder brother examine.
Lordship.
Do you know the name of the elder brother? Do you know the name of the elder brother?
Yes, lordship.
What is the name?
Lordship, page 70.
Page 70. Let us see. What does the elder brother say? Page 70. Cross examination. Sakara Khatun, my own younger sister. Jamila Khatun is my mother. Falu Tara are my grandparent. Oh, he knows everything. Okay, we'll examine notice record interim. He appears to be a real elder brother. Huh?
Yes, Lordship.
Okay, notice record interim.
Item number 10,
Kohinoor.
My lord,
Kohinoor. Yes, what is the problem? Tell us quickly.
my lord, this 71 name was grandmother, grandfather name was mentioned. My lord, this some after 70 years, subsequent, my lord, is some discrepancy, my lord.
That's all, only that. Is discrepancy.
And my lord,
Yes,
this,
Lordship.
Only is this.
Examine.
Okay, notice record interim. Yes.
item number 11,
Manik Jan. Yes, what is the problem? Tell us quickly.
it is expired order.
Ex-party, why? Why didn't you
Because I
go?
were not receive any notice.
You did not receive any notice.
And it was
Then-
it is hang in the wall.
How do you say so?
It is mentioned in the order. Page 27.
Page,
Page 27 is the order.
page 27.
Yes, 28 is the relevant portion, my lord.
27. Let us see, read.
28 is loss of Kali.
Proceeding restart. Sub, okay, but the when in course of fail to print notice sub, but fail to create the required adapter notice issue direction to course service by hanging. And then was hanging at a given address.
One of a shop.
At a concept place in present local. Where it was hung?
It is a wall of a shop.
Wall of the shop. Shop belongs to whom?
No,
Your shop or somebody's?
I have no shop. Near the given address.
Shop at the given address. Conspicuous place in the presence of local Gambra who are known. Yes, sir, what to do? Hanging, huh?
That sounds very.
Lordship means remanded back.
Okay. Considering the nature of the case, Mr. Lane Council for the also Lane Council. Considering the nature of the case, we are of the view that the present petition can be disposed of at this stage. It is a case of the petitioner that the notice was not served upon him properly in accordance with the rules. As it has been submitted, as it can be also, it is also evident from the opinion, impin opinion dated 17/7/2017. The notice was hung on
On the wall of a shop.
on the wall of the shop, on the wall of a shop, on the wall of a shop at a conspicuous place near the given address. Ms. Verma also submits that perhaps there is some irregularity in the manner in which the notice was sought to be served, in as much as there is no such provision for pasting. Then for hanging the notice near at the shop near the place of residence, near a given address. If the notice had been hung on the conspicuous part of the place where the addressee was stated, perhaps there would have been a different matter. We also considered the aspect and found that there is no such provision for pasting or hanging a notice near a place on a place near the address. In fact, such pasting or hanging should be on the place, in a conspicuous in a given address. As far as service of notice is concerned, that is governed by Rule 3, na? Rule 3 of the Rule 3. Order 1960, Rule 3, na?
Order 3, Lordship.
Or sorry, Order 3 of Order 1964 order, huh?
64, Lordship.
Full stop. The said aforesaid order does not provide any such provide for sufficient notice by hanging in a place near the place in a hanging in a place near the place of address, given address.
Highway.
In fact, it should be on a conspicuous place where the person last resided.
Reportedly resided.
Or reported resided.
Again.
Yes. Under circumstances, we also view that the aforesaid mode of service of notice adopted in the present case does not appear to be in consonance with the rules and aforesaid. Since the proceeding by the aforesaid ex parte, the petitioner has been declared a foreigner, which has serious implication for him as he is claiming to be Indian. We are inclined to allow this petition by setting aside the impugn order dated 17/7/2017 and remand the matter for a fresh reconsideration. And since the petitioner has already appeared before this court, there is no need for any fresh notice to be served upon him, and the petitioner will appear before the foreigners tribunal within a period of
1 month.
1 month from today. And thereupon the
I'll submit
thereupon,
written statement.
and then after tribunal will, after giving opportunity to file written statement and adduce evidence, will proceed with the matter in accordance with law.
I'll
Petition says it also made clear that during the pendency of this proceeding, the petitioner will be allowed to remain on bail. Bail bond rupees 5,000 like amount, matrix, biometrics, mobile phone number.
forward.
Item number 12.
Sonowar Ali.
Yes,
Yes, what is the problem?
Here, my lord, father was voter in 1966, 70,
So
up to 85, my lord. Then
85.
father was also, my lord,
Examine.
my lord, not examined, but mother was facing a proceeding, declared not to be foreigner.
Mother is not a foreigner.
Yes, my lord.
Okay.
Lordship will examine the matter.
And then met, okay, not a foreigner. Okay, call for the record interim. In the interim, huh? Notice record interim, huh? Yes. Aitan Nessa.
Item number 13.
Aitan Nessa.
Very pleased, Your Lordship, my lord.
What is your problem?
Judgment is at page 39.
What is the problem?
Page 39, I kindly will look into, Your Lordship. The
Tell us.
relied upon, Your Lordship, voter list of 1970, Your Lordship, sale deed, 1970, Your Lordship,
1970.
70. And 1952 also, Your Lordship, I have annexed, Your Lordship. And more so, Your Lordship, the linkage certificate, the Secretary of the Composite, he deposed on behalf of the opposite party, Your Lordship, establishing linkage, Your Lordship.
Oh,
So, Your Lordship, altogether,
okay, yes. Sir.
Examine
Notice record interim. Yes. Next.
Your Lordship.
Item number 14.
Jayanuddin. Jayanuddin, yes.
Yes, Lordship. Lordship, it's a contested matter, Lordship.
What is wrong with the opinion?
Lordship,
What is wrong with the opinion?
yes, Lordship, there is a shifting in my place.
Shifting.
Yes, Lordship. Moreover, I have casted my vote along with my father in the same village. From 1966, my father casted vote, 1966, 70.
Along with your
77.
father?
Yes, Lordship. 85 also I have casted. from the
Okay,
same
we'll
village.
examine the
Examine.
notice record. Yes,
That's
next.
okay.
Item number 15.
Ambia Begum. Ambia Begum, yes.
May it please, Your Lordship. Lordship, in this matter, Your Lordship, the brother of the petitioner, Your Lordship, who was declared Indian by competent foreigners tribunal, has deposed before the tribunal and that seized my sister, Your Lordship.
Examine lordship.
Notice record interim.
Like,
Admission, Subhas
Admission
Das.
item 16.
Subhas Das, yes, anybody for Subhas Das? What do you want? Tell us quickly.
Yes, yes.
What do you want? Tell us. Record have received, we'll hear.
Lordship,
My lord.
fix it up for
Yes, yes.
hearing, lordship.
Tell us. How long will it take to argue? How long?
Take 20 minutes.
20 minutes. We'll hear some other day.
Some other day,
Okay.
lordship.
The records have been received, the matter will be still for hearing. Yes.
Item number 17.
Noor Muhammad, how long will take?
May I please, Lordship?
How long will you take to argue?
My lord, he is, my lord, already, my lord, arrested, my lord.
Arrested.
Yes,
So what can be done?
kindly, he may be released, my lord, on bail till he
When he was arrested?
my lord, immediately after the, my lord,
When?
my lord,
He hasn't filed a IA for that.
You have not filed also IA
my
also.
lord,
Let
nine,
him come up with
nine,
an
nine,
appropriate
2022, my lord.
lordship.
You filed an IA also. What
My
is
lord,
that?
there is already prayer is there, my lord.
Where is there?
Yeah.
Is there any observation that this will be considered? What prayer? Which prayer is there? List the matter again. Notice. Order was called for. Record, issue notice, no formal. Non-appears petition. You tell us, the records are here, you tell us. How do you say you are an Indian? Tell us quickly.
Today
My
he
lord,
has
here, my
only
lord,
for
as
the
per the order itself, my lord, page, my lord, 39, my lord, 59, my lord.
relevant portion, my lord, here, my lord, DW two, my lord, is a my lord, independent witness, my lord.
Who is DW2? Haimuddin.
Yes, my lord.
That
And-
Abdul Hakim, caste I don't know whether he caste prior to that. He also said from that he knows OP, but family, he has come to know our OP from the voter list, so he knows DW2.
Yeah, my lord.
And who else have appeared? What is that? Noor Muhammad. What is your, show us the affidavit, show us the see document.
My
on
lord,
which
document, my
is-
lord, here, my lord, Panchayat, my lord, certificate, page 52, my
Oh,
lord.
your any earlier document.
Yes, my lord.
What is your father's name?
Father's name is, my lord, Sairat, my lord.
Huh?
His father name will page 31, my lord.
Page 31.
Yes, my lord. Abdul Hakim, and grandfather's name is, my lord, Sairat. my lord.
Abdul Hakim is your father.
Father, my lord. Page 31, my lord, there, my,
And your name appears which voter list?
my lord, it is, my lord, the last total list, my lord, page 37, my lord.
Your 37 is your no, this 2013.
Yes, my lord.
Noor Muhammad.
Yes, my lord. Actually, my lord, they changed their village. Father, my lord, changed his village, my lord.
Have
From-
you stated in that?
Yes, yes, my lord. This is his main case, my lord. This is the
Huh?
problem, my lord. I'm lucky, my lord. This is page, my lord, 11, NHR 1. I'm lucky Ding, my lord. My lord, long back, my lord, his father shifted from this place. Paragraph 5, my lord, in my lord.
Well, did you say that in the written statement?
Yes, my lord.
Where is it?
Page 11, my lord, NHR 1, my lord.
WS.
Paragraph 5, my lord. Then, my lord, he's shifting, my lord, regarding shifting, my lord, relevant paragraph, my lord, page 12, paragraph 7, my lord.
And your evidence, what is your evidence, please?
Page, my lord, evidence, my lord, his evidence, page, my lord, 20, my lord. And chapter 2. And this independent, my lord, evidence, DW to page 21.
You are the only son of your father. You are the only son.
Yes, my lord, other sons are not shown, my lord, in the voter, yes, my lord, voter list.
I casted vote nilly. I could not cast vote with my father. My grandfather is Sirat and I have not seen him. I had here only one son. That is my father, Abdul Hakim. I married some. Yes, Verma. In the
Lordship, we would
cross-examination
like to
also
go
she
through the
mentioned,
records.
she also mentioned that I was 24 years while I was shifting to Nelly from 81 parents.
Today
Want to
we
go
are
through
asking
record?
for
Okay,
bail.
okay, you go through the records when?
Yes.
Tomorrow, day after tomorrow, day after tomorrow?
No, lordship, not so early.
No, so then
My lord, in the
Friday,
meantime, my lord,
Friday.
in the meantime, he may be released, my lord, matter may be hard for the time.
She wants to go through record. In the meantime,
Mal-
she
mal-
wants. Thursday. Okay. Friday. Come
Next
Friday.
week, lordship.
Huh?
My
Next
lord,
week.
kindly, my
Okay,
lord,
next week, Monday.
12.
12.
oblige.
For orders, item number 18.
Rajendra. What is this Rajendra Sharma?
In 18, my lord, I am praying for a little accommodation for today, my lord.
Accommodation.
Yeah.
Okay, on the prayer, Mr. Cotton here. Metabolist again, when?
After vacation, my lord.
After vacation. 2016 matter, read appeal.
Yes, ma'am.
Appeal against what order?
Appeal against the impugned order of the
Which impugned order? Huh?
regarding seniority and other allowances.
What is it?
Pensionary benefit.
What? Ad
Regarding,
hoc period, Mr.
Yes, my lord.
Mr.
My lord.
The law does not permit.
yes, ma'am, that is,
But, here are some.
You are still in service.
I am not in service at this moment.
What seniority you will get now?
Now there are some other considerations. So
What
we will place
consideration?
before your
When
lordship,
did you retire from service?
during pandemic.
2021. Now, after, how can you give seniority now? What is the point of giving
No, I am
seniority?
not going on pressing for any seniority. today.
Then,
But there are some other benefits which
What
we have to be
benefit?
counted
What
with
benefit?
regard to consider if the period which is not considered by the learned single judge, which was my claim before.
well,
the
no,
authorities.
no, you are only concerned about the seniority. Why you are
No,
again?
no, if your lordship would consider the prayer in the writ petition, prayer of the writ petition, which is annexed here with the appeal, then your lordship will find there are some other considerations.
What consideration?
At page 30, your lordship will find 30. These pairs are not considered.
Petition issued calling upon resident to show cause why it so and so, so and so, so and so, you should directly provide all service benefits, including that of seniority, bake wages, increments and other benefits. And that bake wages, if he has served, he will get it. That you examine. Seniority we can't. Bake wages for the work.
That is that period for the minor.
As per rule, admissible rule. What was the direction of this learned single judge? Let us see. What did the learned single say?
Rejected the 65 claim for seniority, my lord.
Oh, seniority, okay, we are not also not inclined. Now after senior, what seniority you
So
will give?
let this matter taken up.
No, 2016 matter, Mr. This will drag this High Court's name, bring bad name to this High Court.
Then.
This High Court cannot dispose of 2016 matter also. What?
Before.
We have to hang ourselves, judges.
He is not.
2016 matter, huh?
Because.
Tomorrow, day after tomorrow. Next, day after tomorrow, yes.
Item 19.
State of Assam, what is this?
Yes, Lordship, there is a delay.
Delay of?
Delay of about 2,100 days.
2100
The
days.
ground was that, Lordship, a review was filed and the review was withdrawn by the council without any instruction from the department. And in between there is COVID also for 2 years. So, and the order is not implementable.
The order is not implementable.
Because it was passed in the month of June 2016, and within 4 months, we have to give regularization under the 2011 Act. In the meantime, during that 4 months period, the act was set aside by this honorable court. So that act cannot be acted upon. So we filed a review application. That review application was pending for 2 years, and finally the council, without any instructions from the department, withdrew the review application. Then we have come to know that review has been withdrawn without our instruction.
See, madam, if the learned AG withdraws, then we can say then there is no need for any instruction. But if the government council withdraws, then there has to be a specific instruction. That is the law.
Exactly, Lordship.
If a council without instruction withdraws, then it is not withdrawal.
And if we pursue, Lordship, that advocate will be in deep trouble. He is our colleague. We do not want
the
to take
learned
that
AG just stands at different footing. If the learned AG says I am withdrawing, then it's the end of the matter. Because we don't ask, the learned AG need not, because he represents the state. So whatever he says, it is taken. But the council, normal government advocate, no, they will require instruction, written instruction, not oral instruction. Oral instruction also not permissible, just like oral transaction of immovable property. It has to be registered. The law requires. So if a council has withdrawn without instruction, that is no withdrawal. The government can only say, I don't know what.
Lordship, it is an internal matter between the.
Correct, it is the internal matter.
council.
Correct.
And the council was authorized to conduct the case.
No, he is authorized to conduct, but he is not authorized to withdraw. That withdrawal requires a specific instruction from the court, from the government.
Lordship,
There is a law, we understand that it has changed, I don't know.
That is
Law
the
keeps changing.
But
And
it's
we are-
intact. That law is intact.
If the law is intact, then we are bound by the law. There are so many decisions of the Honorable Supreme Court.
Lordship.
That
So let the delay be content and let the matter be heard on merit, Lordship, if they are one.
And it was withdrawn on, Lordship, 2019, March 2019, and they are filing this appeal in 22, Lordship. 2 years in between. And on Lordship, 1/12/2020, Lordship, Pritam Saikia personally appeared in the contempt case, in this case, Lordship. And even that he.
Then only we came to know about the withdrawal of the review.
In 2020, Lordship, he came to know about the withdrawal, and he filed the appeal in 22. there is no sufficient lordship explanation of the delay.
The IS filed by you.
Lordship.
And Mr. Learned Advocate General for the state also Ms. So and so for the respondent writ petitioner. The present application has been filed for condoning a delay of how many days? How many days?
2,100.
2,106 days.
One second. The delay appears to be quite inordinate. Yet the law is settled that if there are reasonable reasons assigned, the court may consider condoning delay. Therefore, we proceed to examine whether there was reasonable reasons for coming to this court at such a belated stage. It has been submitted by Learned Advocate General that, first of all, the counsel who represented the state in WPC number, in the writ petition,
In the review.
in the review petition, in the review petition filed earlier,
Yes, Lordship.
earlier seeking review of the impugn order, withdrew without any specific instruction from the state. Thus, in absence, thus the state authorities were not aware of the such unauthorized withdrawal of the review petition filed at the instant of the state. In fact, the state came to know about it, withdrawal only after contempt petition was filed.
Lordship.
To stop. Otherwise, also it has been submitted that that the state is in a piquant situation in as much as the direction issued by this court was to regularize the service of the writ petitioner in terms of the Provincialization Act, which
2011 Act.
2011 Act, which was, however, withdrawn, was set aside.
Set aside by
Was
the-
set aside by this court after 4 months of the passing of the state.
During that 4 months period,
Was set aside subsequently by this court.
yes, on 23/9/2016.
And under such circumstances, though there may have been some lapses on the part of authorities, not to consider regularization during the subsistence of the act. Nevertheless, once this act has been set aside, the state could not have proceeded to consider regularization. Full stop. Under the circumstances, we also the opinion that the further it has been submitted that that there has been in the meantime the COVID also struck, delaying, causing an enormous delay in filing this application. We have also heard Ms. Who submits that the aforesaid explanation cannot be said to be proper in as much as the authorities were very much within their power and authority to implement the court's order within 4 months when the act was still subsisting. From next para. Be it as it may, all these aspects can be considered in the appeal, in the review which has been filed by the state. However, as far as the delay in filing this review petition is concerned, we are satisfied that the reasons assigned by the state appear to be reasonable under the circumstances narrated above, and accordingly we allow this application by condoning the delay of so many days. How many days?
2106.
In filing this review petition. Accordingly, let the review petition be
Lordship, it is
listed.
not review. Now we have filed a writ appeal.
Okay, read appeal,
Before
filing the
also it
appeal.
was
Okay,
writ appeal.
okay. जितना review read appeal
Last
filing
paragraph.
the accordingly let the read appeal be registered and be listed for consideration next week. Yes.
Highly obliged. Lordship.
That may be fixed, Lordship. It is-
Huh?
That may be fixed, Lordship. It is 2000.
Next week. It will come up next week.
Deeply.
Obliged.
My lord, small pair, regarding item number 16, let me kindly fix on next Monday because interim stay is not there. Kindly fix on next Monday.
Well,
Interim.
Subhas Das,
Yes, sir.
you are a foreigner. You have been declared a foreigner.
Yes, sir.
You will stay. Don't worry. You are in detention in the jail or what? You are
No,
in
no,
jail.
not yet, Not yet.
Oh, yes,
Monday
Verma. He has not got any interim order. He is scared of the police visiting his house. In the meantime,
Yes, Lord.
okay, Likho. Since the matter will be listed for hearing in usual course, it has been submitted by Lana Council for the petitioner that the petitioner has not been detained on the stand of the impugn order, impugn opinion dated of the tribunal.
9 July 18.
Huh?
I think 9 July 18.
Don't say I think, you please tell us. You can't think now.
9/7/2018.
2018, pass in,
18,
pass
9/7.
in, yes, pass in the FT case number.
FT case number
4D/5/2015.
सब लिखना हाँ.
D5/2015.
He may not be detained. However, he will appear before the SP border. Which district? Huh? Silchar. And finally, a bond of 5,000.
Last
Security.
occasion, this honorable court has directed accordingly appeared on 21st. In the last order, direction has been
What
given.
is saying?
In terms of order, we have already appeared.
Interim, I don't know what you are saying again.
Last order passed on 26. Order for this.
Bail is there.
Deported from India. Bail bond is their contact number.
Then why you are mentioning? Why? What is that?
No. On 26/10, this court has passed order, but no interim stay is granted. But he
Huh?
appeared. In terms of court's order, he has appeared on 21st, 11/22. But no interim is mentioned in this order. That is a.
Until further that court, the prisoner shall not be deported from territory of India pursuant to the MP.
But then what about the bail?
It is made clear that giving full after president on his appearance, superintendent police borders shall also take necessary.
But then bail order to
Bail
नहीं
will
दिया
be
ना. Not be detained. Appears सब लिखो. You have appeared.
Yes.
But have you given your surety? Bail bond also no.
Yes.
You just appear.
Already appeared.
Appear. You can appear again.
In
You
terms
appear
of.
again.
In
You
terms of.
again appear. Go with the bail bond. 5,000 surety also take along with him. Give a mobile phone number also. You have a mobile phone. Give everything. Next. Next. Yes, what do you want? What do you want? Yes.
I beg to mention item number 2.
2 years. What do you want?
I'm for the respondent.
Okay.
This matter may kindly be taken after vacation.
On the prayer of Mr. What is your name? Your name.
S.A. Akib.
Huh?
S.A. Akib.
S.A.
S.A. Akib.
Akib. On behalf of A. Mubarak.
A. Mubarak. My seniors are out of it.
There are 6 adjourned. I say praise that the matter will list after vacation. As he's out, as the said conducting counsel, Mubarak is out of station. You have informed the other side? You have informed us?
Yes, Lordship. Lordship, I beg to mention item number 5, my lord.
Yes, what do you want?
Mr. B. Pathak is admitted in a hospital. My
Oh,
lord.
I see.
So this matter may be taken on 21st.
On the ground of indisposition of Mr. B. Pathak, Lane Council for Response 1, 2, 3, the matter stand adjourned. How many days?
Fixed on 21, my lord.
Adjourned to 21 December.
Yes, my lord. I have already taken the.
Okay.
Deeply, lord.
Next.
Lordship, I beg to mention item number 1.
Yes.
Adjournment matter.
You are for whom? For the petitioner.
Petitioner.
What is your name?
C. Talukdar.
Sita Rao. And you have informed the other side?
Yes, I informed that.
Mr. C. Talukdar mentioning on behalf of whom?
S. Sharma.
S. Sarma. Lane Council petitioner. The matter stand adjourned.
Lordship, kindly next week.
We don't know. Next week after 2. Yes, next.
Daily list for orders item 3.
What is this? Item number 3.
May please, your lordship. Lordship, it is for correction of orders,
Oh,
lordship.
correction order. What happened? What is the correction?
The name of the arbitrator, lordship,
Ah.
has been wrongly typed as Hirendra Kumar Sharma instead of
Hirendranath.
Nath Sharma, lordship.
Okay. The present application is filed for correcting the name of the arbitrator, learned arbitrator who has been wrongly mentioned as Honorable Mr. Justice retired Hirendra Kumar Sharma, though the correct name is Honorable Mr. Justice retired Hirendra Nath Sharma.
Sure.
With the above correction, the matter stands disposed of. Accordingly, the necessary correction be made in the order dated
21.
21/11/2022 as far as the name of the arbitrator, Mr. Mr. Honorable Mr. Justice Retired Hirendra Nath Sharma is concerned.
Highly
I dispose of. Yes, next.
For hearing, item number 4.
Sukumoy De, what is this? What is this?
Please, Your Lordship.
May I please your lordship, I'm appearing on behalf of Mr. Ekta. He is on election. I contacted him. He is just coming. And
You are for whom?
I'm for the petitioner.
What is this about?
My lord, it is about pay fixation
Pay fixation of?
of one of the High Court employees, my lord. My lord, he was earlier working in the CBI. And
CBI.
on direct recruitment, he had joined the High Court service, my lord.
Yes.
His pay was fixed, my lord, at the highest of the scale because he was drawing a higher scale in the CPM.
Yes.
Later on, when the ROP 2010 came into force, my lord, on the basis of the 6th State Pay Commission, my lord, his pay was revised. After that, there was a complaint made to the Honorable Chief Justice that he was drawing excess salary. On that basis, my lord, the Chief Justice, relying on certain previous decisions of this Honorable Court, sent the matter for approval of the government of Assam. However, one of the authorities in the High Court, my lord, disregarding the direction of the Honorable Chief Justice, my lord wrote a letter saying that the pay needs to be refixed, pay of the petitioner. On that basis, the state government had made a direction, my lord, directing recovery of certain pay and allowances from the petitioner, and also relegating him to a lower pay. That is the crux of the matter. But if my lord, there is an advertisement at page 38.
Yes.
Page 38 is the advertisement. My lord, here, my lord will see the scale, the pay scale given, my lord, in the first paragraph. It is rupees 5725 to 11,825. This is for the post of stenographer grade 1. Thereafter, my lord,
Page.
page 38, my lord, of the petition, annexure 1.
Page 38.
38, my lord. This
That's
is
the advertisement.
Advertisement dated 23rd of May, 2008.
23rd of May.
2008.
Post of
Post of stenographer grade 1.
stenographer grade 1.
And pay scale, my lord, is rupees 5725 to rupees 11,825.
Yes.
My lord, I was selected, my lord. My appointment letter is at page 41, my lord.
Page 41.
Page 41 is my appointment letter. It's in the same scale of pay, rupees 5725 to 11,825.
Page 41. 5725, 175, 660, 660, 250, 73. 7350 is different.
7350, then efficiency bar, my lord. Then 250.
No, but earlier 7350, but here you have been given, okay, 7350, efficiency bar 250,
No.
then 8100, 325, 1100, 400, 11825.
No.
Then what is your name?
My name, my lord, at serial number 5.
Serial number 5.
My
Then
this is on 26th of December, 2008. Then I resign on technical grounds in the CBI, my lord, pursuant to which, my lord, this is at page 43.
you resign, okay.
My lord.
Page?
My lord, page 43 is my technical resignation. 43, 44. Page
Yes.
45 is the office order releasing me, my lord. And here, the last pay certificate is at page 46. Last pay certificate in the CBI.
Oh, mister, but question is, you have applied for this spot as this pay scale.
Yes,
You
my
will get the pay scale.
yes, my lord. Yes, my lord.
How does, wow, what pay scale you are enjoying, we are not concerned.
My lord, because I was drawing a higher scale,
Doesn't matter.
my lord. So I get my lord.
Doesn't
11
matter whether you are buying a lower scale before you join higher scale,
My-
you will get the pay scale which is given in the advertisement.
Yes, my lord.
Then
Yes.
what is the problem?
No, my lord, I got 11,825, the highest of the scale. Because I was drawing a higher scale in the CPI.
No, whether you are, no, so long it is within this component. First of
it
all,
is.
it has to be component and it is a direct recruitment.
Yes, my lord.
It is not a deputation.
No, my,
Then you will get from the very beginning, like anybody else.
no, my lord.
Why?
My lord, pay protection is to be granted to me.
How, on what basis? Tell us.
My lord,
What technical resignation? You have to resign. You can have two posts.
yes, my lord.
You are earlier working in CBI.
My,
Very good. Then you saw Guwahati High Court.
my lord,
Ah,
my lord.
so you said, I want to work in Guwahati High Court. You applied. And there is an advertisement, the pay scale is there.
My lord,
You got appointed.
my lord.
Then you get that for whatever is providing the
sir.
advertisement.
Lordship is right, my lord.
Then,
I got in that scale only, my lord. I got but the highest of the scale. I was granted the highest of the scale.
what is it? What is it?
My lord.
Pay?
My lord, page 46 is the last pay certificate. Page 46, my lord, we'll see in the left column, my lord, pay band rupees 12,660, grade pay 4,200.
On submission of technical resignation to him, join new assignment.
My lord,
He has been paid up to.
my lord, at the following rates. In the leftmost column, my lord, pay band 12,660. The third row, my lord, under dues.
Pay
Under
ban.
pay band at the rate of rupees
But
12,660.
you are a CBI, a central government
Yes, ma'am.
undertaking.
Yes, my lord.
And that you may have a different pay scale.
Yes, my lord.
And our High Court has a different pay scale.
Exactly, my lord.
Then-
That is my case.
Ah,
That is exactly
so
my
your pay
case.
scale and whatever the High Court is offering, you accept it.
No, I got that, my lord.
Then what is the
That is
problem?
exactly my case, my lord.
And then
My lord.
what is your grievance?
My lord. My lord may now come to the next page, my lord. At
Page?
page 48, my lord.
Yes.
My lord, it's the office notes, my lord,
Whose office note?
of the High Court.
How does it matter?
Oh, no, my lord.
Let the office write whatever one you give, the office will give whatever this pay
My
is
lord, this
given.
was approved by Honorable the Chief Justice, my lord.
Oh, you cannot be given a different pay than what is advertised.
No, my lord, I was given that same pay scale, my lord. In
Then
that same pay scale. Lordship will kindly come, my lord, to the second last paragraph of page 48, my lord.
yes,
From the service book of Sri Day, it is seen that his basic pay plus grade pay is rupees 16,860 on 1/7/2000. It should be 9, my lord. My lord, 2008. As the maximum of basic pay of the post of stenographer grade 1 is rupees 11,825, the basic pay of Sri Day may not be allowed at a stage higher than that of rupees 11,825 under the rules. This is in that scale, my lord. This was approved, my lord. And my lord, I was being paid thus my salary in at the rate of rupees 11,825, the highest of that scale.
but then
There is no dispute on that.
yes, then
My lord. Thereafter, my lord, the ROP 2010 came into force. ROP rules 2010. I joined, my lord, on 9th of January. Yes, my lord, I was
but
released.
this
on-
ROP is about High Court, not about CBI.
Yes, my lord. No, my service in CBI is over then, my lord,
over.
after joining.
Ah,
After joining, my lord, I joined the High Court at rupees 11,825 being my pay.
mhm,
My lord, that is exactly what I am on, my lord.
mhm.
My lord, after joining in the High Court, I joined the High Court, my lord, on my lord, 9th January 2009. The ROP rules came into force in 2010. My lord, when the ROP rules came into force, my lord, at page 52, my lord will see this is the form for fixation of initial pay. This is exactly what lordship, what is fallen from lordship.
Yeah.
My lord, serial number 6, existing scale of pay rupees 5,725 to 11,825. That is the advertised scale. basic pay in the pre-revised pay scale from the date on which revised pay structure is applicable, rupees 11,825. Pay in pay band by applying multiplication factor of 1.86 subject to maximum in the pay band, rupees 22,000. Grade pay 5,900. So the initial pay was fixed at rupees 27,900 after the ROP rules came into force. My lord, this 27,900 is, my lord, 22,000 is the pay in pay band and grade pay of rupees 5,900. So that comes to 27,900. This is all right, my lord, according to me. As lordship has said, earlier service was in CBI. When I joined, my lord, I was given a pay scale at rupees, the pay in pay scale at rupees 11,825. On application of the ROP rules 2010, my lord, this 11,825, as per the fitment, it came to rupees 27,900. I was paid that. There is no dispute up to here. My lord, there was an anonymous complaint after this. On basis of the complaint, my lord, in the meantime, my pay in CBI was revised again. It was even raised higher with arrears and all. I'm not bothering lordship with that because that was in my earlier service. My lord, then my lord, page 60 to page 60, my lord, 60 is my regularization in the High Court.
Yes.
Page 62 to 65 is the complaint. I'll not bother lordship with that. Page 66, lordship may kindly come.
Page 60?
Page 66, man. Annexure 30.
Yes.
This is the office note, my lord, of the registry. This, my lord, refers to the complaint made against me, my lord. I'll not bother lordship with going through everything, my lord. My lord, last is at page 67, verify the facts stated in the complaint and report back immediately. After this, my lord, is the Honorable Chief Justice's note at page 7.
Page?
70, my lord. Next annexure, annexure 14. This is regarding anonymous representation dated 18/3/2013 in respect of pay fixation of Sri Sukamoy De, stenographer grade 1. It is alleged that Sri Sukamoy De is drawing higher pay by wrong representation of facts. The record, however, reveals that Sri Sukamoy De, while serving in the CBI, applied for the post of stenographer grade 1 through proper channel. After being selected and appointed, joined the High Court service on 9/1/2009. He was granted pay protection on the basis of last pay certificate issued by his parent department by invoking the provisions of FR 2222C. He was also granted lien by his parent department. Therefore, as per provision of law, he is entitled for protection of pay. Incidentally, in the case of Sri D.S. Doctor, a retired stenographer grade 1 of this court may be referred to. In his case, the Office of the Accountant General observed that Sri Doctor, having come from the government of Mizoram to the services of the Guwahati High Court, was not entitled to pay protection. Such a plea was raised in spite of judicial pronouncements by this honorable court in Nandeshwar Kolta and others versus Registrar Judicial Guwahati High Court and others, reported in so-and-so, which was upheld by a division bench in Nandeshwar Kolta and others versus Registrar Judicial Guwahati High Court, reported in so-and-so. The plea of the Accountant General has been rejected by this court in decision dated 4/3/2013, passed in WPC so-and-so, which was also upheld by a division bench of this honorable court in writ appeal number so-and-so. It may be mentioned that while fixing the pay of 3 days, suggestion has been given to the effect that the government of Assam may be moved for fixation of pay, but this has not been done. In view of the matter, if it pleases your lordship, the matter may perhaps be referred to the government for approval. My lord, this line, my lord, matter may be referred to the government for approval of the pay granted by the High Court. And Honorable the Chief Justice has agreed. Down below, lordship will see the Honorable Chief Justice's signature saying yes, allowed. Yes. My lord, after this is the office note. My lord, may come to the last paragraph. As approved, the matter regarding fixation of pay of Sri Sukamoy De, Steno grade 1, may be referred to the Finance Department of the Government of Assam for approval. As proposed as above, the account section may take up the matter as it relates to pay fixation. Superintendent to do the need. My lord, this was done. Till here it is okay, my lord. After this, there was a letter written by the Deputy Registrar of Finance to the Government of Assam, my lord, saying that if lordship comes to page 74.
Yes.
In view of the above, you are requested to take the matter of fixation of pay in respect of Sri Sukamoy De with the Finance Department of the Government of Assam and to intimate the views of the Finance Department in the matter to this registry at the earliest. My lord, this authority goes against the direction of the Honorable Chief Justice. Honorable Chief Justice has approved and the sending of the matter to the government of Assam for approval. But the authority in the registry, my lord, he writes to the government saying that it needs to be refixed. This has created the problem. That is why we are before lordship. After this, the government, as usual, my lord, they would be for payment of less salaries. They have directed, my lord, recovery and reduction in pay. My lord, the letter from the government is at page 79.
Yes.
My lord, with reference to the subject of cited above, I am directed to furnish herewith the observations made by the Finance Department in connection with fixation of pay of Sri Shilpa Moide, stenographer grade 1, Guwahati High Court, as shown below. Finance Department observed that last pay of rupees 16,860, that is pay in pay band rupees 1260 plus grade pay 4,200, drawn in the former post under the 6th Pay Commission of the Government of India, may be protected and fixed at the stage of pay of rupees 19,070. That is pay in pay band rupees 13,170 plus grade pay 5,900 of new post in the scale of rupees 12,000 to 40,000 pay band 4 with grade pay 5,900. That is under the 6th Pay Commission of the Government of Assam on his appointment joining as stenographer grade 1 in the office of the Registrar General, Guwahati High Court, with effect from 1/9/2009 with DNI 17/2010 as per provisions of Rule 11 of the Assam Services ROP Rules 2010 read with FR 22(1)(a)(1), subject to the condition that the post involves assumption of duties and responsibilities is of greater importance than of the former post and in consultation with the relevant records, such as service books, records, etc. My lord, after this, there is a letter from the registry, my lord, directing recovery of rupees 10,72,086 rupees and refixation of my pay at rupees 19,007. My lord, earlier it was 27,990. Now, my lord, they have reduced it to 19,070 per month and recovery of rupees 10,72,000. Aggrieved thus, my lord, I had approached this honorable court by way of a previous petition. There was a direction to consider my representation. That representation was considered and rejected, my lord. That is why I am before elections.
What is the rejection of the consideration?
My lord. My lord, page 104, my lord. 104 is the communication. Thereafter is the order from page 105. They have extracted the Finance Department's observations, my lord, in the bold paragraph, my lord. Sorry. Whole paragraph at page 105, they have extracted the Finance Department's observations, which lordship has read. Thereafter, my lord, page 106.
The 6th Pay Commission, when is that? It was your last drawing, last drawn was 16,000, no?
My lord,
According to you.
16,000.
That is as per the 6th Pay Commission
In the central government.
in the central
In the
government.
central government. I joined, my lord, well before the 6th Pay Commission report was in the government of Assam, was approved. The ROP rules came into force in 2010. I had joined on 9th of January 2009.
No. See,
My-
6th Pay Commission of Government of India.
My lord,
So when you are working
my lord,
as the stenographer in CBI,
my lord.
what was the rule applying at that time?
6th Pay Commission.
6th Pay
Sixth
Commission.
Pay Commission. I have
6th
joined.
Commission have already implemented, so
Yes.
you are enjoying that.
My lord.
So you are entitled to the 16,860. That is 12,660 plus
My lord.
4,200
In the central government.
in the
Yes.
central government.
Yes,
On joining registry, his basic pay was fixed at 11,825.
my lord.
How do you fix 11,825?
The highest of the scale, my lord,
Highest of the scale.
by getting paid for it.
The insurance was fixed at 112. The maximum of his basic pay of the stonemasson revised pay was 11,825.
The fixes thus Sri Day appears to have received the benefit of the 6th Pay Commission of the central government with effect from 1/1/2006.
Since you are drawing
My-
16,860, which
My-
is higher than the highest in the
in the High Court scale.
High Court said, therefore you automatically got,
My
because of pay protection.
My lord,
Therefore, you got this 11825,
my,
though it is lower than your CBI.
my,
Ah.
my.
Thus, they appear to have received the benefit of 6 pay commission from 2006,
Six.
while he was under the employment of CBI so and so.
Right.
On the date of his joining the High Court on 9/1/2009, the revised pay in regard to staff officer of High Court was not in existence.
Right.
How does it matter whether it was in existence
Exactly,
or not?
my lord. Exactly.
Because he will get his pay protection, he will get his protection in whatever terms and condition
Yes,
you are
my
there. And central government had implemented 6 pay commission.
Yes, my
So you are enjoying 16,860.
My lord.
If you had not joined government of Guwahati High Court, you would have continued to draw
My lord.
16,860.
My lord,
Huh?
my lord. my
But
lord.
then by joining this service of the High Court,
My,
you are getting 11825.
exactly,
And you want to continue to get that.
my lord.
That's all.
That is the.
And then, okay, it does appear to have received the benefit of 6 pay commission from while he was under and so on the date of his joining High Court on 9/1, the revised pay in regard to staff officers was not in it. Revised pay of the state,
Yes, my
nothing to do with the center.
lord. Nothing to do with this.
However, as an interim measure, pay of the officers High Court stood revised with effect from 1/1/2006. As per Assam Service ROP Rules 2010, thereafter the basic pay of the C-day again be revised and fixed at 27/9 so and so, 22 pay plus 15 GP with from under the pay commission of the government of Assam of the Community Force of 2010. So you got a revision, you get a
Yes,
benefit of the Assam revision, ROP
Yes.
2010.
My,
When a matter was brought to notice of the so and so, fixed so and so, finance observed the last pay drawn from may be protected and fixed. Finance observed that the last pay of rupees 16,000 so and so drawn in former post under 6 pay of India may be protected and fixed at the stage of rupees 19,000.
19,070. My
Is
lord,
it correct?
my lord, according to the finance department, finance department is not calculating at rupees 11,000. Here is the mistake committed, my lord. When I joined High Court, my lord, my
You are getting 11.
11,000.
You are not getting 19.
No, my lord.
Ah.
No, after application of ROP 2010, they say it is to be 19,000
ROP 10 of the state.
state.
And what is wrong with that?
My lord, the wrong, my lord, is 11,825
Yes,
in the pre-revised.
yes,
That comes to 27,900.
900. Yes.
Not 19,000.
Oh, okay.
If that is brought to 19,000, then the corresponding, my lord, pay of 19,000 will be the scale, meaning thereby my pay would have been reduced from the date of my joining.
So according to you,
My-
the government of Assam, the finance department had wrongly calculated to
Yes.
be 19,
My
though it should be 27
20,
is fixed.
my, my,
Huh?
my,
What is that fixation of 27? Why is that order?
my lord. This is at in the IPS, my lord, page 52.
Page 52. And this has been fixed by the
Fixed by the High Court. my
High
lord.
Court.
My lord, by
Basic
application.
pay, we instructed April 1/1.
1,184.
Pay in the pay band, so subject to minimum pay band 22.
My,
Grade pay 5. So as far pay band in this pay band is 22,000 as per the new revise.
Mine.
Okay?
Mine.
New revise.
mine,
And grade pay also revised to 5,900. So 22 plus 5,900 is why you're getting. So
27.
27.
And this was approved by Honorable the Chief Justice. My lord,
The question is,
Mine.
when this calculation was made on 24/3/2010,
mine,
this
Mine.
annexure P8,
mine.
was this correctly calculated to
Yes, ma'am.
27?
Yes, my lord.
Huh?
This is as per the fitment table, my lord, of the
Wow.
ROP.
Okay.
Uh,
Can we have a look in that
yes, of
fitment
course,
table? So the government of Assam wrongly recalculated it
Yes, my
by
lord.
saying instead of 29, it should be 19.
My lord.
Let us see that fitment.
It will be serial quick.
This fitment table
My
is
lords.
as per your 2010 ROP, huh?
ROP 2000 of the state
Of
government.
the state
My
government,
lord,
yes.
serial number 23,
Cell number 23,
23.
8425, Basic.
18,000, sorry, my lord, 11,825.
just a minute. Serial number,
Fourth last, my lord,
okay, fitment table 22,
22, my lord,
serial number
23.
23, 11825.
This is
Earlier,
118,
okay, 11825.
my lord,
Now it will be revised to 22.
22.
Then grade pay will be
5,900,
5,900. So you'll get
27.
27,900.
My-
So
as
this
per
is the
fitment.
fitment.
As per the fitment people,
Okay.
as per the ROP.
So therefore you are given this.
I was given
Now
this.
the government somehow has miscalculated it.
My,
On what basis 1910 will be there?
my
You
lord,
say go
the
1910?
the government of Assam,
Assam, suppose let us go by
My
Assam, how they have calculated it.
my lord,
Let us try.
my lord,
See,
my lord,
Then
they have gone
19,
on
what
the,
is the 19?
my lord, we have to do a back calculation.
Yes, that's what. Na?
My,
How do they do back calculation? You want to see that? Okay.
my lord.
Assam service, আমার pension rule নাই নাকি? আছে? 2010
ROP rules.
ROP rule আছে?
এটাই হয়তো। Oh. Ram Sophia. My lord, it will be in between those two highlighted. It's fine. Yes,
But then how did the basic pay assume to be 6850 or 710? From
That-
where they get it?
that is my case, my.
Oh,
By that, my basic pay would come down to 6,000 or 7,000, my lord. That is not my basic pay. my
because your basic pay is
11,000.
11,825. Because you
is-
have been protected.
Yes, my lord,
Because that is the last pay you enjoyed.
my lord. The highest of the
High,
scale,
higher the same.
highest of the
So
scale,
you are enjoying some 27 or something like that.
17,000.
17. So you get at least 11.
11.
That is the which is provided.
My lord, the calculation made by the government of Assam,
Finance,
finance, my lord,
so according to is erroneous. huh?
erroneous because my basic pay would then be reduced, my
It
lord.
is. Now what does the High Court say?
My
Let
lord,
us see.
my lord,
We'll
page
read again.
106.
Page 6, yes. Then
Street
see, they
day,
had already got benefit of pay revision while doing service CBI, and hence he perhaps will not be entitled to pay benefit as per Assam, which may refer to he however would be entitled to pay protection. Accordingly, the payoff was refixed in terms of the above to which it appears to have agreed. While refixing his pay appears to have given preference in terms of the above. Effects and so and so and so. And it is ROP, Assam ROP came in 2010,
2000.
but with effect from 2006.
And insofar as I am concerned, it will be from the date of my joining,
That is
9 January 2009.
9/2009.
My,
Hmm.
and they went on a wrong premise. If I go by the affidavits, my lord, they are relying on rule 11 of the ROP rules. If my lord kindly goes through rule
Sorry,
11,
you join on
9/1/2009,
join High Court on 9/1/2009.
2009.
And High Court Assam Pay
2010.
rules ROP 2010 came into effect
22/1/2010,
22/1/2010
by notification FPC 85 of 2009,
by notification
number FPC
dated
dated 22/1/2010.
no effect from which date?
Effect from 1/1/2006,
1/1/2000.
1/1/2006.
1/1/2006.
My,
And but by in 2006, you have already enjoyed the revision as per 2006 pay commission
in the central
in
government.
the central
In the
government.
cent-
The government is saying that you cannot have this double benefit.
Exactly.
Until let us see rule.
My lord, rule 11 of the ROP rules 2010 is relied on by the government.
Where is it? Rule?
My lord, my book, my,
Why did you take a copy of this?
my lord. No,
Yeah,
my lord, I'll
Amar,
read from here. my
No,
lord.
no, you.
I have the.
Nine, Amar nine.
No,
Assam Service Revision of Pay Rules 2010 9. Amar High Court or 9. Why? Oh, अरे तो आनो.
No, my lord, I'll take the book from my friend. My lord.
I have given.
My lord. They are relying on rule 11.
Rule 11.
Rule 11,
Let us see rule 11.
page 46, my lord.
Page 46. Yes. Fixation of pay on promotion. Promotion.
Exactly, my lord. That is where
In
they're
case
wrong.
of promotion.
This is not a
This is not
promotion.
promotion. Why are invoking rule 11?
is something different, my lord. Lordship will kindly hear.
Individual, but anyway, as far prima facie, 11 is not applicable. This is for promotion.
What is applicable, my lord, is rule 12.
Okay. Fixation of pay in the revised pay structure subsequent to 1/1, where a government employee continues to do his pay in the existing scale and is brought over to the revised pay structure from a later date, then his pay from the later date in the revised pay shall be fixed by adding the basic pay applicable on the later date. So what is the basic pay applicable on the later date?
11,825, my
Huh?
lord. 11,825.
His pay from the later date
My
is brought about the revised pay structure from a later date in 1/1/2006, where the government continues to do his salary, his pay in the existing scale, and is brought over to the revised pay structure from a date later than 1/1/2006, and you join in 2009. His pay from the later date in the revised pay structure shall be fixed by, so on 2009, on the 2009, you shall be fixed by adding the basic pay applicable on the later date.
My lord.
What is the basic pay you entitled on the later date?
11,825.
The DNS applicable on the date and so and so, so and so, so and so. This figure will be rounded to the next so and so, so and so, so and so, in addition to this so and so. So you said that say rule 12 will be applicable.
Rule 12, my lord.
Not
rule
11.
11.
Okay. And
They are
they say rule 11. Why they say this is rule 11?
My lord, they know why, my lord.
No. Why they have mentioned that it is 11?
My lord, because they are trying to backdate my lord pay scale to 1/1/2006. Their contention, my lord, is that I cannot have the benefit of this revision under the Central Pay Commission and again under the State Pay Commission. My lord, whereas
No. What is, I don't understand one thing. What is DNI?
Date of next increment.
Okay.
Date of next increment usually is 1st of July, my lord.
So that is your case.
That is my case.
Let us see what the government's, what the.
My lord, before that, my lord, some judgments.
Huh.
Exactly similarly situated, my lord. I'll not bother lordship with the entire bunch. Of course, my lord, the pages are a bit old. I prepared this a long time back, my lord. Exactly similar case was of Dibyendu Shekhar Datta.
Page.
This is my pagination, page 13 onwards, my lord.
13.
1-3. Para 17.
Dibyendu.
Dibyendu, DS Gupta, my lord.
Okay.
Is retired now.
Yes.
Para 17, if lordship comes to. At my page 17, my lord.
Yes.
My lord. Mr. Medhi, learned standing counsel of the High Court, submits that the petitioner joined the Guwahati High Court as a stenographer grade 2 in the pay scale of rupees 670 to 1500 pre-revised scale. He was released by the Mizoram government on 12/6/1989 and joined his new assignment on 13/6/1989. On his joining, his basic pay was protected at rupees 1500 under FR 22. Thereafter, as per ROP rules 1990, the corresponding basic pay of the petitioner was fixed at rupees 3275 in the revised pay scale of rupees 1475 to 3835 with the approval of Honorable the Chief Justice. Then Lordship may come to para 20. Or my Lord, yes, ma'am, para 20. These I am reading because Lordship will have an idea of the facts in that case, my Lord. Mr. C. Borua, learned counsel, appearing for the respondents 4 and 5, submits that the petitioner received benefits under the 4th Central Pay Commission with effect from 1/1/1986, as at that time the Mizoram government was following the Central Pay Commission. After his appointment to the High Court Registry, his pay was again revised with effect from 13/6/1989 under the 4th Assam Pay Commission. Objection raised is that pay of the petitioner was protected under both the 4th Central Pay Commission as well as in terms of the 4th Assam Pay Commission within a service period of 4 years, initially on 1/1/1986 and thereafter on 13/6/89. This discrepancy came to the notice of the respondent number 4 only after receipt of the pension case of the petitioner on 7/1/2010. Respondents 4 and 5 were not parties, so and so, my lord. Then Lordship may come to para 23. Petitioner, on joining the registry of the High Court on 13/6/1989, in the pay scale of rupees 670 to 1500, his basic pay was protected as rupees 1500 under FR 22/22C, just like my case, my lord, in the highest of the pay scale.
FR will give to FR, yes.
Thereafter, as per ROP rules 1990, the corresponding basic pay of the petitioner was fixed at rupees 3275 in the revised pay scale of rupees 1475 to 3825 with the approval of Honorable the Chief Justice. Thereafter, on his promotion to the post of stenographer grade 1 on 13/11/1990, his pay was fixed at rupees 3575 in the pay scale of rupees 2275 to 4450. This was subject matter in a writ proceeding before this honorable court in 1999, 1 GLT 307. This is in the first punch. Wherein the present petitioner was also arrayed as a respondent. A single bench of this court held that all the relevant matters were placed before the competent authority. Thereafter, the fixation of pay was worked out in conformity with the provisions of FR 22C. It was placed before Honorable the Chief Justice, who approved the same. After observing that no mala fide or improper exercise of power could be inferred, the single bench categorically held that pay fixation was done lawfully by the authority of as per the statutory rules. The officers' persons were recruited from different sources and they were given protection. When the matter was carried in appeal, a division bench of this court in 2002, 2 GLT 691 affirmed the findings of the single bench and held that materials on record disclosed that the competent authority of this court granted pay protection to the respondents of that case, including the present petitioner, on the basis of pay which they were drawing in the parent of departments or offices. On the face of record, no illegality, mala fide, or improper exercise of power was discernible in the decision of the competent authority to fix the basic pay of those respondents on the basis of their higher pay in the parent department's offices by invoking the provisions of FR 22/22C. My lord, now my lord may come to para 26. Article 229 is extracted, my lord. From a careful perusal of the aforesaid article, it becomes evident that it is the Chief Justice of the High Court who is the competent authority to deal with the administrative expenses of the High Court, including all salaries, allowances, and pensions payable to or in respect of the officers and servants of the High Court. The above article was examined by the Honorable Supreme Court, though in a somewhat different context in the case of M. Gurumurthy versus Accountant General Assam and Nagaland, reported in 1971 to SCC 137. It was held that once an order has been passed by the Chief Justice of the High Court in exercise of his powers under Article 229 of the Constitution, the only course open to the government, if it wanted to challenge such order, was to take resort to appropriate proceedings, either way by of persuading the Chief Justice to rescind or amend his order on the administrative side, or to file a writ petition challenging his order in the High Court. The action of the government in that case in directing the Accountant General was not to issue any payslip to the appellant until further orders of the government were issued, was deplored. In M. Gurumurthy Sutra, which was a case from this court, the Apex Court explained the object of Article 229 in the following words. The unequivocal purpose and obvious intention of the framers of the Constitution in enacting Article 229 is that in matters of appointments of officers and servants of a High Court, it is the Chief Justice or his nominee who is the supreme authority and there can be no interference by the executive except to the limited extent that is provided by the article. This is essentially to secure and maintain the independence of the High Court. The anxiety of the constitution makers to achieve that object is fully shown by putting the administrative expenses of the High Court, including all salaries and allowances and salaries, allowances, and pensions payable to or in respect of officers and servants of the High Court at the same level as the salaries and allowances of the judges of the High Court, nor can the amount of any expenditure so charged be varied even by the legislature. Thus, Article 229 has a distinct and different scheme and contemplates full freedom to the Chief Justice in the matter of appointments of officers and servants of the High Courts and their conditions of service. These can be prescribed by rules made by him. Apart from the special situation contemplated by the proviso to clause 1, the only exception is that the governor's approval must be sought to the extent the rules relate to salaries, leave, or pensions. This exception is abundantly clear, had to be made because the finances have to be provided by the government, and to the extent there is any involvement of expense, the government has to approve of. My lord, this is insofar as the powers of the Chief Justice. In this case, my lord, the Chief Justice has not made any other rules that require the approval of the government. My lord, here he has applied the rules which are there and rules made by the government. And my lord, by application of the ROP 2009, the Honorable the Chief Justice had directed, my lord, the payment of my salaries at rupees the corresponding to 11,825 at rupees 27,990. My lord, this was as per the ROP 2010. He had merely referred the matter to the government for approval.
So Chief Justice has not made any rule?
No, no rule. The rules are already, the ROP rules were as an interim measure at that time applied to the High Court, because ROP 2010 was not applicable to officers and servants of the High Court.
So you mean to say that the Chief Justice has not made any rule for revision of the salary? Huh?
No, man.
So you mean to say that is ROP 2010 is not applicable or what is it?
The ROP itself says, my lord, it is not applicable to the High Court. But as an interim measure, my lord, this was applied to the High Court. My lord, that document I have stated in my repetition, but that.
So if the ROP 2010 is made applicable, do you get prejudiced or what? No.
No, my lord. No, my lord.
So whether it is applicable or not, how does it matter then?
No, my lord.
Unless you say that by applying 2010, my case will be prejudiced.
No,
then you can say,
then. No, my lord. What I was on, my lord, is that Article 229,
Yes.
it requires, if rules are made by the Chief Justice, then they have to be sent for approval of the government.
Yes.
In this case, no rules have been made. In this case,
So accordingly, therefore the question of getting approval of the government does not arise.
does not arise.
No, that is for approval of the rules,
Exactly, my lord.
but not.
Yes, since the salaries come, my lord, therefore the Chief Justice had referred the matter to the government for approval, not for fixation. But the registry made a mistake and sent the matter for consideration for fixation or refixation. That was the mistake committed by the registry. Chief Justice's note is clear, my lord. It is to be sent to the government for approval.
So since the Chief Justice approved the fixation of pay scale,
My lord. Pay, my lord.
fixation of pay of the petitioner,
My lord. At rupees 27,990.
it was sent to the government for approval.
Approval. But my lord, the registry officials, they overreached the order of the Honorable Chief Justice.
In what way?
My lord, they wrote to the government for consideration for refixation, not approval. If my lord comes to the letter written by the registry, my lord, this is at page
Page?
sorry.
Yes.
My lord, page 74, my lord,
Page 74.
74.
Now the question arises as to whether these entitled to receive revision under
Right.
in view of the your request to take the matter for fixation of pay, take up the matter of fixation of pay in respect of its final department and to intimate a view of it.
This is overreaching the orders of Honorable the Chief Justice, my lord. Order of the Chief Justice is at page 70, my lord.
Page
Page 70, my lord, 70, my lord. The second last paragraph, my lord. It may be mentioned that while fixing the pay of Sri Day, suggestion has been given to the effect that the government of Assam may be moved for fixation of pay, but this has not been done. In view of the matter, if it pleases your lordship, the matter may perhaps be referred to the government for approval. And Chief Justice notes, yes, my lord. And here-
approval of what?
approval of the pay, my lord, because, my lord, the previous paragraph, DS Doctor is referred to, my lord. The judgment which, the paragraphs which lordship
This is
has referred-
regarding the anonymous representation.
My-
In respect of anonymous representation is against you.
against me, my lord.
It is alleged that Sukuma is drawing higher pay by wrong representation of facts. That however reveals that the record, however, reveals that Sukuma, while serving applied for so-and-so after being joined the service, he was granted pay protection on last year so-and-so. He was also granted lien by this department. And therefore, as per provision, he is entitled for pay protection.
My-
Incidentally, the case of the so-and-so retirement may be referred to. In his case, the office of the accounting officer having come from government of Mizoram to the service of Guwahati High Court was not entitled to pay protection. It was held by this court that
Yes,
he is
but-
not entitled to pay protection.
That he was entitled to pay protection.
No, was not entitled to pay.
My lord, it was observed, the Accountant General observed.
Oh, account, okay.
This was
Office of
rejected.
accounting was not entitled. Such a plea was raised in spite of the judicial pronouncement so-and-so reported, which are upheld by division bench. This plea of accountant general has been rejected by this court so-and-so, passing so-and-so, and others which are upheld by this one. Fixation of pay has been given. While fixing the pay of Sri Day, suggestion has been given to the effect that the government of Assam may be moved for fixation of his pay. But this has not been done. So, fixation of the if
May perhaps be referred to the government for approval. That is the last.
no,
My
correct.
lord,
It may be mentioned that while fixing the pay of Sri Day,
my lord.
suggestion has been given to the effect that the government of Assam may be moved for fixation of his pay.
My lord,
But this has not been done,
my lord,
thereby meaning
my lord.
that the Assam may be moved
My-
for fixation of pay. You cannot say, why didn't you write, according to him, according to you, then RG could have written,
My lord.
or the registrar vigilance could have written that however he has been fixed at 2022, 22,
My lord.
or is that
My lord, 27, 990.
999, and this may be placed before the government for approval.
My lord.
Then that is very clear, but here the language is not very clear. The
My-
third para, it
My-
says,
My lord.
it may be mentioned that while fixing the pay of Sri Day, suggestion has been given to the effect
My lord.
that the government of Assam may be moved for fixation of his pay.
But the fixation has not been done. 70.
But this has not been done.
This has not been.
What
done.
has not been done?
The fixation by the moving the government of Assam for fixation of the pay. Rather, my lord, the pay was fixed by the High Court.
Then why the High Court is again writing that
Thereafter, my lord.
move
that-
for fixation of his pay?
My lord.
No, the
My lord,
pay has been only fixed by the High Court.
by the High Court.
Then why it is written may be moved for fixation of pay scale? That means the High Court still thinks that your pay scale has not been fixed.
My lord,
Finally,
my lord, because my lord, he says suggestion has been given. It is on that suggestion.
in
There
that
was a-
view of the matter, if it pleases your lordship, the matter may perhaps be referred to the government for
for
approval.
approval.
Approval of what?
Approval of my pay, of my pay.
That is also not very clear
That
now.
is not clear, but it is understood, my lord. This suggestion, my lord, thus there was a suggestion that the government of Assam may be fixed, may be moved.
For fixing.
For fixing them.
I thought for
But-
fixing, that means it has not been fixed, but
No.
according to it has been fixed.
Yes, my lord.
But then why did the High Court write it for fixing of pay? That means High Court is not sure whether it's been fixed or not.
My lord, but the initial pay statement, my lord, which lordship will see at page 50.
That fixation, the High Court perhaps is not sure. That is why you moved the High Court, the government, Assam may be moved for fixation of his pay.
My lord, that is in respect
But
of
this
the
has not
suggestion.
been done.
My lord. My
The High
lord,
Court has not, even that fixation 22,
My lord,
22, 27,900
my lord.
has not been approved by the government of Assam.
It
Has
has
it
not
been
been.
approved?
It has not been,
Was it required to be approved?
not required,
Not required.
not required. But the lordship has written, my lord, that the matter may perhaps be moved, placed before the government for approval.
Approval of what? What is to be approved? That approval means what? Approval for approval of what? Approval for moving the government. What is to be approved? The
My
two
lord,
things. See, if you
My
read,
understanding.
no, correct. I have understood. But what I'm saying is that this last para,
It's a bit ambiguous.
yeah, ambiguous.
My lord.
That the chief says yes. Chief also says, what is yes? Yes. Now, if it pleases your lordship, the matter may perhaps be referred to the government for approval.
My lord.
Now, reference, yes. For approval of what?
My lord.
Approval of what?
My lord, here.
Approval of what?
My-
What is to be approved
My-
by the government? It is
Here-
also not clear.
It is a bit ambiguous, I understand, my
There
lord.
is a problem, no?
But my lord. before
Now,
that-
if it is ambiguous,
My-
let it be, let it be, okay? We cannot change the language now.
My,
Assuming that it is ambiguous.
My-
Now, irrespective of ambiguity, you have to be given some pay,
my lord,
salary.
yes, my.
What is the salary you have to be given?
2799,
2799.
my. lord.
Because that
As
is
per
what you are
page-
entitled to.
Yes, my. lord. As per page 50. The initial pay slip.
And that this government, the proposal that pays, What is
The government's letter, my lord, is at page, my lord, 78, my,
78,
78.
78.
Right.
That Assam don't produce so and so under 6 pay. Finance observe the last pay of 16,860.
Right.
Drawn in form of post 6 pay, it may be protected.
Right.
So the Assam government also agrees that it may be protected
Protected.
and fixed at the stage of pay of 19,097. This so far is also correct? No.
No, my. Here they
Protected and fixed at the stage of, now, the last pay of 16,860, where is it? The last pay you are enjoying, 16,860?
My lord, in the CBI, my lord, 16860. In the fitment table, serial number 23, my. lord. Fitment table 22,
Last pay 16,860.
16860. Fitment table 22, my lord, of the ROP rules.
The finance department observed the last pay of 16,860.
My lord.
Where is this 16,860?
My lord. If it is
16,860, where is it?
16,
What is it from? Where they get this 16,860?
my lord, 16860 was my last
Page
pay in the
46, my
CBI.
Page 46,
Page?
46, my lord.
Page
The
46.
last pay certificate.
In the CBI, my.
Okay. Page 46.
12,660 plus 4,200.
12,660
Plus
plus grade pay 4,200
Yes,
drawn in the form of post may be protected.
my.
In that case, 16860 may be protected.
My.
Therefore, and the fix at the stage of 19, from where they get this 19?
Exactly, my. That is.
Because if 16860 is to be protected,
My lord,
you will get the maximum as per the advertised post.
Yes,
That is
ma'am.
11 something.
11825.
11.
11825.
And if 1182 and 1182 stands revised to 27900.
My lord,
That is your case.
my lord,
So this 1970 from where they get, it is not explained.
that is not explained.
So they have to explain.
My lord.
So the
If,
High Court has to explain. And the
uh,
government also has to.
government also
Government
has
is there.
finance-
Hey, where is the government? Hey,
Finance,
government, where is the government after creating all this problem?
finance is not.
Finance is not there.
Is a party, my lord.
Where is the finance?
Right.
Because what Mr. Das will say that no, finance says this. We'll ask the finance, how do you come to this?
My lord, because if it is 19,000, my lord, then it comes to my salary, my basic pay would come in between, my lord, 7,100 to 6,850, not 11,825. In fitment table 22, my lord, in my highlighted portion, my lord.
See, if I've understood again, subject to what Mr. Das will say.
Right.
Mr. Das says finance has written this, that we are doing it, isn't it?
I'll say, my lord, I'll satisfy your lordship this, where from this 19,000 comes, my lord. I have got the documents, my lord. I'll satisfy.
But then finance also has written
Let
it.
them satisfy, my lord. I can also satisfy, my lord, because this is a settled proposition of law, my lord. How the fixation is to be done.
Okay,
My lord.
okay, very well.
My lord. Yeah, my lord, irrespective of that 19,000 or
Okay.
27,000, my lord, there were decisions I'll rely on in my bunch, my lord.
Yes,
The first one. It's Nandeshwar Kolita, my lord.
Yes.
2002, 2 GLT 691. Relevant paragraphs 20 and 22. This is of the revision bench. Nandeshwar Kolita. Paragraphs 20 and 22, my lord.
yes.
My lord, at my page 9.
Yes,
It has been the specific case of the respondents number 5, 6, 7, and 8 that before joining the services of this High Court, they were serving under different state governments offices drawing higher scale of pay, and that after being selected for appointment in High Court service, they were granted pay protection on the basis of last pay drawn by them in their parent department's offices by invoking the provisions of FR 2222C by the competent authority of this court. The aforesaid stand of the respondents 5 to 8 has been supported by the registry of this court. Sri Choliha, Learned Senior Counsel, appearing for respondent number 1, confirmed the above position by producing the connected official records. On the prayer made on behalf of the appellants, the learned counsels were permitted by this court to examine the records to controvert the above stand. Nothing has been pointed out to us to suggest otherwise. It is nobody's case that the respondents 5 to 8 did not hold any lien. Sorry, did not hold any lien against the post held by them in the parent department's offices. It is not in dispute that they were selected for appointment in the High Court service. It is not the case of the appellants that FR 2222C is not applicable to the employee staff of this court. The contention raised on behalf of the appellants is that the precondition for application of FR 22 or 22C are not satisfied in the insert case. The exercise on fixation of initial pay of the respondents 5 to 8 after their selection for appointment in the High Court has to be undertaken either prior to or simultaneously with their appointment. It is not the case that the basic pay of the respondents 5 to 8 has been fixed years after their appointment in the High Court service. It is not the dispute that they were drawing higher pay before their appointment to the High Court service. To hold that immediately upon their selection for appointment to the High Court service, the lien of respondents 5 to 8 in their post in the parent department's offices cease to exist would render FR 22 otious for all purposes. It is our view that FR 22 to be meaningful and realistic in its meaning and content. The lien held by an incumbent on an earlier post would continue till he is appointed substantively in another post. His initial pay is fixed and he acquires lien thereto. Our view is reinforced by the provisions of FR 14A, which lays down that the government servant's lien on a post is no circumstances would be terminated even with his consent if the result would be to leave him without a lien or a suspended lien on a permanent post, and that his lien on a post would stand terminated on his acquiring a lien on a permanent post outside the cadre in which he is born. The materials on record disclose that the competent authority of this court granted pay protection to respondents 5 to 8 on the basis of pay which they were drawing on the parent department's offices. With regard to submission made by the Learned Senior Counsel for the appellants that FR 22C could be applied only if the incumbent concerned is appointed to a post carrying duties and responsibilities of greater importance, suffice it to mention that such an assessment would involve an element of vague judgment or value judgment and has to be left to the wisdom of the competent authority. As alluded above, the competent authority, on a consideration of the materials on record, decided to fix the basic pay of the respondents 5 to 8 on the basis of their higher pay in the parent department offices by invoking provisions of FR 2222C. On the face of records, no illegality or malafide or improper exercise of power is discernible. My lord, then para 22, my lord. This takes us to the plea that the principle of equal pay for equal work. This aspect of the matter has been succinctly dealt with by the Apex Court in its decision recorded in 1989 to SCC 290 in the state of Andhra Pradesh and others. Appellants versus G. Srinivasa Rao and others respondents, extensively quoted by the learned single judge in the impugned judgment. The question which fell for consideration before the Apex Court was whether payment of less salary to a senior than his junior in the same cadre will have the same having the same pay scale is violative of the principle of equal pay for equal work enshrined in Article 39B, read with Articles 14 and 16 of the Constitution of India. It was held that doctrine of equal pay for equal work cannot be put in a straitjacket, and though in terms of various judgments, the right to equal pay for equal work has been held to be an accompaniment of the equality clause enshrined in Articles 14 and 16 of the Constitution of India, the abstract doctrine of equal pay for equal work cannot be read in Article 14, and a reasonable classification based on intelligible criteria having nexus with the object sought to be achieved is permissible. We extract herein below the relevant portion of the judgment, which according to us is a complete answer to the questions raised on behalf of the appellants in this issue. 15, equal pay for equal work does not tell that all members of a cadre must live the same pay packet irrespective of the seniority, source of recruitment, educational qualifications, and other incidents of service. When a single running pay scale is provided in a cadre, the constitutional mandate of equal pay for equal work is satisfied. Ordinarily, grant of higher pay to a junior would expressly be arbitrary, but if there are justifiable grounds in doing so, the seniors cannot invoke the equality doctrine. To illustrate, when pay fixation is done under valid statutory rules, executive instructions, the persons recruited from different sources are given pay protection. When a protectee from a lower cadre or a transferee from another cadre is given pay protection, when a senior is stopped at the efficiency bar, when advance increments are given for experience, passing a test, acquiring high qualifications, or incentive for efficiency, are some of the eventualities when a junior may be drawing higher pay than his seniors without violating the mandate of equal pay for equal work. A bare reading of the above extract would unequivocally proclaim that when pay fixation is done under valid statutory rules, executive instructions granting pay protection, and thereby a junior in service is granted higher pay, the senior cannot invoke the equality doctrine. But in this case, DS Doctor was also a party, which is referred to, my lord, in the judgment Lordship has already read, my lord, in respect of DS Doctor. In DS Doctor, my lord, this is on pay protection, on granting of higher pay. My lord, in DS Doctor, my case is exactly similar to that of DS Doctor. Because DS Doctor at that point of time, in fact, in my affidavit in reply, my lord, I have prepared a table, my lord, pointing out the similarities. If my lord takes up my affidavit in reply.
Yes. Page.
My lord, page, it will be, my lord, page 14, table A.
Affidavit in reply.
To the affidavit of respondents 2, 4, and 8.
Affidavit reply repetition page.
Page 14, my lord.
14.
14. This table A, Lordship finds. Page 14, my lord. There are two reply affidavits.
Which one?
My lord, to the affidavit in opposition of respondents.
When did you file this affidavit reply?
My lord, this was my lord in my lord, July 2015. I'm sorry, my lord, I don't have the exact date. July 2015.
Yes,
my lord. This is in respect of the affidavit in opposition of respondents 2, 4, and 8, my lord. In the cost title, Lordship will find up my reply.
And reply in affidavit. In reply to 21 July. Page 14.
Page 14, my lord. Thanks.
Yes.
My lord. In the first one, my lord, is Dibyendu Shekhar Dutta, DS Dutta. His date of joining in the High Court was 13/6/1989. And pay scale in the earlier department, that was government of Mizoram, was my lord 1,400 to 2,600. This was revised with effect from 1/1/1986, my lord. And his basic pay was 15,000, sorry, my lord, 1,520. Now, my lord, when he joined the High Court in the fourth column, my lord, he joined the High Court in the scale of pay 670 to 1,500. This was below, my lord, 1,520, which was his basic pay in the government of Mizoram. Therefore, he was given pay protection and basic pay was fixed at rupees 1,500. The ROP rules 1990, my lord, they were notified on 31/12/1990, and his basic pay was revised to 2,968 from 1,500 in the pay scale. Now, in my case, my lord, next page, my lord.
Yes.
I joined on 9/1/2009. My pay scale, my lord, was 9,300 to 34,800 in the CBI, my lord. This was revised from 1/1/2006. And my lord, I was drawing the pay at the pay band of rupees 12,660 and grade pay 4,200. This is 16,680. My lord, when I joined in the High Court, my lord, in the last column, in the rightmost column, my lord, the pay scale was 5,725 to 11,825. My basic pay was fixed at 11,825, similar to DS Datta and the highest of the scale. When ROP rules 2010 were notified on 22/1/2010, after my joining, my pay was fixed in the pay band rupees 22,000 and grade pay 5,900, which comes to, my lord, 27,900, corresponding to 11,825. This was the similarity.
No, in the ROP 2000 came,
My
pay was revised to, your pay was revised at pay band rupees 22 plus grade pay.
my
So it should be rupees 29,
27.
27,900.
27,900. This is corresponding to 11,825.
Hmm.
As was the case of DS Datta, which, my lord, 1,500 was revised to 2,968.
Hmm.
My lord, this was the similarity between DS Datta and me, my lord. In DS Datta, this honorable court held that this fixation was right. And this was, Lordship had read the single bench's judgment. Then a division bench judgment is there, my lord, from page 20 of my bench, my lord.
But the division bench was dealing with
No, that was Nandeshwar Kolita on pay protection.
pay protection and about the equality of, I think, equal
Yes.
pay for Nandeshwar Kolita.
Nandeshwar Kolita.
Nandeshwar was a pay, equal pay for equal work.
Yes, fine.
So there, on this division bench said that just because you are holding the same post
My lord,
and you may be junior,
my lord.
does not mean that you cannot get higher pay.
Exactly.
Because various things like you have passed in, you have
Right.
done PhD, some increment
Working in a different.
or something like that. So more, some all those things may be there.
My.
Increment and all this, then allowances, additional allowance and all these things
My,
which you get because of your working, you have passed this this test, that exam,
my, my.
So how is it relevant to this case?
My lord, because in that case, in the first judgment which Lordship read, Nandeshwar Kolita, the first judgment of this bunch, my lord, Nandeshwar Kolita, in Nandeshwar Kolita, my lord, DS Datta was also a party. His pay protection was fixed. Thereafter,
DS Datta was also party.
was also a party.
Who is DS Datta?
Dibyendu Shekhar Datta, which is the second judgment, my lord, from page 13.
Dibyendu was a party in that.
In Nandeshwar Kolita.
I mean, but he may be a party, but he may be a party, but for other purpose. But
yes, for the purpose of pay protection. And thereafter, my lord, DS Datta's case, in which Lordship had read for the first time from page 13, my lord.
yes,
In DS Datta, this benefit of 4th Central Pay Commission under the government of Mizoram, joining the High Court service and thereafter being granted fourth Assam State Pay Commission's recommendations benefits, my lord, was an issue.
Dipendo,
Dibyendu Shekhar Datta from page 13, my lord,
page 13. no?
2013, 2 GLT 815.
Hmm.
My lord, the relevant paragraphs, my lord, 17, 20, 23, 26, and 27, which lordship has read.
So this Dipendo, in Dipendo, High Court simply said that yes, a fixation is permissible.
Permissible.
That's all.
Yes,
Not,
my lord.
but there was no other issue raised.
There was no issue. This is similar to my issue, my lord.
Mhm.
Because the issue raised in Dibyendu Shekhar Datta
Mhm.
is he had got the benefit of fourth Central Pay Commission under government of Mizoram. After getting that, he was enjoying that salary. He joined the High Court service when in the pre-revised scheme. After joining in the High Court service, Assam revision of pay, pay commission recommendations were made and they were applied to him. He got the benefit under the Assam revision of pay. Like me, my
In your case, there are only 6 pay commission
Six
and the
pay-
2000.
2000.
The difference is that, but otherwise, you are entitled to the revision in the Assam revision also.
Yes, my
We-
corresponding to
for-
11,825, as was done in Dibyendu Shekhar.
Hmm.
In Dibyendu, it's fourth minus sixth. Now, Dibyendu Shekhar Datta, my lord, the accountant general had appealed. This was dismissed. The appeal was dismissed by the division bench from page 20, my lord.
In Dipendo Shekhar Datta,
My lord.
fixation of pay was challenged.
Yes, ma'am.
What was the ground of challenge
He got the benefit under fourth Central Pay Commission
in Dipendo Shekhar?
in Dibyendu Shekhar in his earlier service.
Huh.
Thereafter, joined the High Court service. After joining in the High Court service, Assam Fourth Pay Commission recommendations were made. They were applied, and he got the benefit.
That was challenged.
That was challenged.
And that was under this court, this division bench says that no. No.
Initially single bench, the judgment which lordship had read is a single bench. Thereafter, the division
Okay.
bench.
No, but then. No, but initially, Dipendo Shekhar was upheld
Uphill.
by a single bench. He said you can get this benefit.
ma'am.
There is
Yes,
nothing
ma'am.
wrong. And this was appealed by Nondeshwar Kalita.
No, my lord, no, my lord.
Who is this
Nondeshwar
Nondeshwar?
Kolita is prior in point of time. The issue in Nondeshwar Kolita, my lord, was juniors getting higher salary.
So that is a different issue, no?
Yes, that is a bit different, my lord, but that was, I was on because of this equality clause of
Achha,
article.
therefore I was got confused
My-
because Nandeshwar Kalita was in a different
My-
issue.
My lord. But-
No, not the issue which you are raising.
No,
Okay.
but in Nondeshwar Kolita, Dipyendu Shekhar was a party. Because his.
Oh, again, why are you bringing this
My lord,
Nandeshwar Kalita again?
My
Oh,
lord,
forget it all, they know each other, they have tea every day, but doesn't mean that, why are you bringing this Nandeshwar Kalita again and again in Dipyendu? Dipyendu, according to you, is squarely applicable.
My lord,
That's it.
my lord.
Then why you want to bring Nandeshwar?
My lord.
Because there may
his-
be party,
My-
they know each other.
My lord.
Because the issue in Nandeshwar was a different,
Was
whether
higher.
a junior can get a higher pay
Yes,
scale, that's all. Why
yes.
you bringing?
My lord.
Is any relevant? I don't know about with this case,
The relevance-
except that Nandeshwar and Dipyendu were together.
the relation, my lord, is because in Nandeshwar, they were getting the highest of pay scale. In my case, 11,825, they were also getting the highest of pay scales. That was upheld by the division
Okay.
bench.
Okay.
In Nandeshwar, Dipyendu was one of the parties. That is the reason, my lord. And thereafter, this Dipyendu Shekhar Datta judgment of the single bench is later in point of time. When
And this Dipyendu Shekhar Datta has not been appealed or something like
my lord,
this.
the accountant general has appealed, that was dismissed. The appeal was dismissed
Acha.
by the division at page 21.
Oh, page 21,
My,
even dismissed.
dismissed,
Okay, this WA 91.
my lord.
Okay. And while dismissing, what did the this division bench observe?
My lord, the second
2020.
paragraph,
Yes.
this is the reason why I kept referring to Nandeshwar, my lord.
Okay.
Learned single judge held that once fixation of pay has been duly finalized as per judgment of this court dated 25/11/98, rendered in civil rule so-and-so, reported in so-and-so, Nandeshwar Kolita, and affirmed by the division bench by judgment dated reported in so-and-so, objection of the appellant was misconceived. It was noted that correctness of pay fixation was not challenged even by the finance department of the government, and the stand of the appellant to the contrary cannot be upheld. We have heard the learned counsel for the parties. It has not been disputed that pay fixation of the writ petitioner has attained finality under orders of this court. Only contention raised on behalf of the appellant is that Accountant General was not a party to the pay fixation. We are unable to accept the submission. Accountant General was not a necessary party in a matter of pay fixation. Learned single judge rightly held. In the present case, the government has not even questioned the decision of the High Court. On the contrary, it has given ex post facto approval to the decisions of the High Court, which on re-examination was reaffirmed. It was in such circumstances, the Accountant General could not have raised the objection to pay protection granted to the petitioner by the High Court, which had the approval of Honorable the Chief Justice. We are in agreement with the above observation. Once pay fixation of the petition has attained finality and the Accountant General could not raise objection thereto, the action of the appellants in not releasing pension, gratuity, and other retirement benefits of the petitioner cannot be held to be legally. My lord, this Dibyendu Sekhar, my lord, is squarely applicable in my case. Now, my lord, M. Gurumurthy, lordship has already read the extract. I'll not bother lordship again with going through M. Gurumurthy. Then on the recovery portion, the other judgments, my lord, from Bhagwan Shukla, if lordship comes to the first page, I've given an index.
Yes.
They are all on recovery. That recovery is not permissible if I have not paid any fraud. I have not paid any fraud, my lord. So recovery is not permissible. There is a recovery of 10,72,000 and all, my lord, as per the direction of the government. That is not permissible in view of Bhagwan Shukla, Rafiq Masi, then Dipendra Thakuria, All Manipur Degraded Teachers Association, Syed Abdul Qadir, PJ Akkara. Lordship knows these judgments. And I have given the relevant paragraphs. Lordship desires I can read the paragraphs.
Yes.
My lord. In Bhagwan Shukla is paragraph 3, my lord. This is my pagination 31 to 33.
Yes, yes.
At page 30.
No opportunity given.
My
Then and Rafiq Masi.
Rafiq Masi, no fraud.
Yes, yes.
My
Para
lord,
number.
para 4, 6, and 7. Page 33 to 45. Para 4, lordship will find at my page 37, my lord. Merely on account of the fact that release of these monetary benefits were based on a mistaken belief that at the hands of the employer, and further because the employees had no role in the determination of the employer, could it be legally feasible for the private respondent to assert that they should not be exempted on refunding the excess money received by them? Insofar as the above issue is concerned, it is necessary to keep in mind that the following reference was made by the division bench of 2 judges of this court, was considered by a larger bench, Rakesh Kumar. In view of the apparent differences of views expressed in one hand in Shyam Babu Verma versus Union of India and Sahib Brown versus State of Haryana, and on the other hand in Chandi Prasad Unyal versus State of Uttarakhand, we are of the view that the remaining special leave petition should be placed before a bench of 3 judges. The registry is accordingly directed to file the remaining special leave petitions before the Honorable Chief Justice of India for instructions for constituting a bench of 3 judges to adjudicate upon the present controversy. Then, my lord, para 6. In view of the conclusions extracted herein above, it will be our endeavor to lay down the parameters of fact situations wherein employees who are beneficiaries of wrongful, in my case, it is not wrongful, my lord, wrongful monetary gain at the hands of the employer may not be compelled to refund the same. In our considered view, the instant benefit cannot extend to an employee merely on account of the fact that he was not an accessory to the mistake committed by the employer, or merely because the employee did not furnish any factually incorrect information on the basis whereof the employer committed the mistake of paying the employee more than what was rightfully due to him, or for that matter, merely because excessive payment was made to the employee in absence of any fraud or misrepresentation at the behest of the employee. Then, my lord, para 7. Having examined the number of judgments rendered by this court, we are of the view that orders passed by the employer seeking recovery of monetary benefits wrongly extended to employees can only be interfered with in cases where such recovery would result in hardship of a nature which would far outweigh the equitable balance of the employer's right to recover. In other words, interference would be called for only in such cases where it would be iniquitous to recover the payment made. In order to ascertain the parameters of the above consideration, the test to be applied, reference needs to be made to situations when this court exempted employees from such recovery, even in exercise of his jurisdiction under Article 142 of the Constitution. Repeated exercise of such power for doing complete justice in any cause would establish that recovery being effected was iniquitous and therefore arbitrary, and accordingly interference at the hands of us.
Okay, we'll continue.
My
I think we need to hear the government also.
My lord,
Finance.
my lord,
Finance
finance is.
I'll ask Mr. Gogoi. Mr.
But
Gogoi.
My friend is here.
who's appearing for finance?
Lordship, Mr. R. Borpujari appears. my
Board
lord.
Pujari, okay.
But today there is some inconvenience.
No
my lord.
problem, but anyway, we'll hear
Yes,
the.
Lordship,
Hear the.
Dipendranath Thakuria, this is 2015 4 GLT, page 32. My page 46 to 49. Lordship may come to page 49. My page
Yes.
of our High Court, my lord. In view of the law laid down by the Apex Court and Rafiq Mashi and others, it is not necessary for this court to enter into a determination as to whether salary drawn by the petitioners were in excess of their entitlements or not. This is so
Yes.
because even if we presume that the salary drawn by them was in excess of their entitlements, they would still stand protected from recovery by virtue of situations 2 and 3 as mentioned above. Admittedly, on the date of issuance of the impugned orders dated 17/9/2013 and 18/9/2013, petitioner number 1 was due to retire within 1 year, whereas petitioner number 2 was due to retire just above 1 year. The alleged excess payments were made for a period of about 24 years before issuance of the impugned orders. In such circumstances, the court is of the view that recovery sought to be made from the petitioners would not only be impermissible in view of the law laid down by the Apex Court, but also be harsh and iniquitous on the petitioners, since such recovery would have to be made from criminal benefits. In view of the above, both are sentenced. Then my lord may come to 2005 2 GLT, page 32. All Manipur Decreed Teachers Association versus State of Manipur at para 6. My page numbers 50 to 52. Lordship may come to para 6, my lord. At page 52. It is settled law that higher pay scale given erroneously to incumbents without any default or of theirs shall not be recovered. The interest of justice demands that where service of an employee has been utilized by a state in a particular post after upgradation, he shall, upon degradation from the state post, be entitled to get the salary and allowances of that higher post for the period during which he was holding the same. Excuse me. Then, my lord, 2009 3 SCC 475, Syed Abdul Qadir versus State of Bihar. My page numbers 53 to 70. Your lordship may come to para 57. My lord, at my page 69.
Yes.
This court, in a catena of decisions, has granted relief against recovery of excess payments of emoluments, allowances, if A, the excess amount was not paid on account of any misrepresentation or fraud on part of the employee, and B, if such excess payment was made by the employer by applying a wrong principle for calculating the pay allowance on the basis of a particular interpretation of rule or order, which is subsequently found to be erroneous. My lord, in my case, their stand is on an erroneous computation of pay, I was given higher salaries. That is their case. So this is insofar as recovery is concerned. All these judgments. Then para 59 also. Undoubtedly, the excess payment has been paid to the appellant teachers was not because of any misrepresentation or fraud on their part, and the appellants also had no knowledge that the amount was being paid to them was more than what they were entitled to. It would not be out of place to mention here that the finance department had in its counter affidavit admitted that it was a bona fide mistake on their part. The excess payment was made as a result of wrong interpretation of the rules that was applicable to them, for which the appellants cannot be held responsible. Rather, the whole confusion was because of inaction, negligence, and carelessness of the officials of the concerned government, officials concerned of the government of Bihar. Then counsel appearing on behalf of the appellant teacher submitted a so. Then my lord may come to Colonel B.J. Akkara, my lord. Para 27 and 28. My page is 71 to 92. At 27, my lord, at page 9. My lord, The last question, para 27, the last question to be considered is whether relief should be granted against recovery of the excess payments made on account of the wrong interpretation, understanding of circular dated so and so. This court has consistently granted relief against recovery of excess wrong payment of emoluments allowances from an employee if the following conditions are fulfilled. By Sahib Ram, Shambabu Verma, Union of India versus M. Bhaskar, V. Gangaram. A, the excess payment was not made on account of any misrepresentation or fraud on part of the employee. B, such excess payment was made by the employer by applying a wrong principle for calculating the pay and allowances or on the basis of a particular interpretation of a rule or order, which is subsequently found to be erroneous. 27 and 29 is not so relevant. 28, my lord, such relief restraining back recovery of excess payment is granted by courts not because of any right in the employee, but in equity in exercise of judicial discretion to relieve the employees from hardship that will be caused if recovery is implemented. A government servant, particularly one in the lower ranks of service, would spend whatever emoluments he received for upkeep of his family. If he receives any excess payment for a long period, he would spend it genuinely believing that he is entitled. As any subsequent action to recover the excess payment will cause undue hardship to him, relief is granted in that behalf. But where the employee had knowledge that payment received was in excess of what was due or wrongly paid, or where the error is detected or corrected within a short time of wrong payments, court will not grant relief against recovery. The matter being in the realm of judicial discretion, courts make on facts and circumstances of any particular case refuse to grant such relief against recovery. My lord, Sahib Ram, Shambabu Verma, para 11, my lord. These are all on the similar things, para 90, page 93 to 98. My lord, Shambabu Verma, para 11, my lord. At my page 97. Although we have held that petitioners were entitled only to the pay scale of rupees 330 to 480 in terms of recommendation of the Third Pay Commission with effect from January 1, 1973, and only after a period of 10 years they became entitled to the scale of rupees 330 to 560. But as they have received the scale of rupees 330 to 560 since 1973 due to no fault of theirs, and that scale being reduced in the year 1984 with effect from 1st January 1973, it shall only be just and proper not to recover any excess amount which has been paid to them, already been paid to them. Accordingly, we direct that no steps should be taken to recover and adjust any excess amount paid to the petitioners due to the fault of the respondents. Then, my lord, Sahib Ram versus State of Haryana, para 5 on page 99. It's the last paragraph. And my lord, admittedly, the appellant does not possess the required educational qualification. Under the circumstances, the appellant would not be entitled to relaxation. The principal erred in granting him the relaxation. Since the date of relaxation, the appellant has been paid salary on the revised scale. However, it is not on account of any misrepresentation made by the appellant that the benefit of higher pay scale was given to him, but on wrong construction made by the principal for which the appellant cannot be held to be at fault. Under the circumstances, the amount paid till date may not be recovered from the appellant. My lord, in my petition, my lord, there are two parts of the impugned order. One is reducing my salary. The second part is recovery of 10 lakh 72,000 and more. These judgments which I am relying on, my lord, from Bhagwan Shukla to Sahib Ram, they are on the recovery portion, my lord. This pay scale was given to me, my lord. It was no fault of mine. In fact, I'm entitled to that. So therefore, that recovery portion should not be there, my lord. It should be washed. And insofar as the refixation at the lower scale, my lord, that is patently erroneous, my lord. Because my service initially was a central government service. I was enjoying 16,000 and odd as my basic pay. When I saw the advertisement here, I joined. My lord, I had a DA, and there is no corresponding, my lord, requirement that if the central government, my lord, constitutes a pay commission for its employees, there has to be a pay commission and its recommendation needs to be accepted by the state government. My lord, there may not be a revision of pay in the state services. My lord, knowing that, I had joined. And while I had joined, my lord, there was a lien on my service in the CPI. 2 years had gone by, my lord. If I was paid a lower scale than 11,825, my lord, I may have gone back, my lord, because I was given the offer, my lord, at 11,825 on the highest of the scale. I was enjoying that. And when I became a state government, a government employee of the High Court, my lord, that 11,825 corresponds to 27,990, my lord, under fitment table 22 of the ROP rules. So I am entitled to 11,825 as on 1st January 2000, sorry, 9th January 2009, which corresponds to 27,000 upon application of the ROP rules. Now, their calculation of 16,000 or 19,000, my lord, that 19,000 is, if it is applied, my lord, the basic pay would come to 7,000 under the fitment table. Lordship has already seen the back calculation from in the fitment table. If that 19,000 is taken to be the scale, then I would be paid salaries at 7,000, which is far below the 11,855, which I have got. But that is, in my humble submission, my lord, not permissible. So in my humble submission, my lord, I am to be paid at 27,000. And insofar as that portion of my lord hardship being caused to me, my lord, I have annexed those documents. I had taken loans and all, my lord, housing loan. My lord, I am paying my EMI and everything, my lord. So, and my son also is studying in a good engineering institution. All those fees, if it is, if the salary is reduced, I will not be able to pay that. So the hardship portion may also be. My lord, so far these would be my submissions, my lord.
And Mr. Learned Counsel for the petitioner in this, we'll just note down the submission. And this petition, the petitioner has challenged. What is that order?
My lord, impugned order, my lord. Sorry, my lord. From the government of Assam, page 78, and
Page
from the
78.
page 78,
The
9/7/2014.
order issued by the Judicial Department,
Yes,
Judicial Branch of the Government of Assam, by dated 9 July, later by has added order of the Judicial Department, Judicial Branch of the Government of Assam is contained in the communication dated 9 July 2014, whereby the whether it was communicated that the petitioner would be will be entitled to 19,070 upon fixation of pay scale after application of the ROP of Assam Services Delivery ROP Rules 2010, which was also adopted by the state government, which are also by the High Court.
Applied by the High Court.
Applied by the High Court, contrary to the observation of the Honorable of the Chief Justice, also to allow the petitioner to enjoy the earlier pay scale of rupees 27,900, and thereby seeking to recover the alleged excess payment of salary to the petitioner. Full stop. The brief fact, yes.
Another impugned order, my lord, page 80.
Page
80.
And accordingly had challenged also the order communication dated 1/8/2014 received from the Guwahati High Court, issued by the Guwahati High Court to the petitioner for fixing the pay scale, fixing the pay scale of the petitioner, pay of the petitioner to a lesser amount of rupees 19,070, and for seeking to recover an amount of 10,72,086 on the alleged ground of excess drawal by the petitioner. Next paragraph. As we Mr. Nair, Learned Counsel has drawn attention to the factual background of the case, which we would like to reproduce here and below, which we would like to refer briefly. Petitioner was before he joined service in the Guwahati High Court as stenographer grade 1, was earlier serving as a stenographer grade 1?
No, my lord, stenographer group D, my lord.
Group D, stenographer group D, stenographer group D in the Central Bureau of Investigation, group D, in the year 1989. full stop. Upon his completion of 12 years of service in the CBI, he was granted a higher pay scale under the Assured Career Progression Scheme of the Government of India, thus fixing his pay at rupees 5500 dash in the scale of rupees 5500 dash 1750 dash 9000 with effect from 1/6/2002. When the petitioner was serving in this CBI, as mentioned above, he responded to advertisement issued by the Guwahati High Court for appointment to the posts of stenographer grade 1, in which the pay scale was prescribed as rupees 5725-175-660-250 EB 250-8100325. देख लेना. The petitioner accordingly applied for the said post. How many posts were advertised?
My lord.
Advertised how many posts? How many posts? How many posts were advertised?
13, my lord. 13, 1-3. my lord.
1-3. Pursuant to the said advertisement, the petitioner also applied for one of the posts for appointment to one of the posts through the proper channel. Accordingly, full stop. The petitioner, having found successful in the recruitment process conducted by the Guwahati High Court, was offered appointment, and accordingly the appointment order. What is that appointment order?
Page 41, my lord, 26 December.
Accordingly, the petitioner was appointed as to the post of stenographer grade 1 along with 8 other candidates in the pay scale of rupees 5725 dash page 41 में देख लेना pay scale full stop. Since the petitioner was already working on regular basis in the CBI, and since he had applied for the said post by obtaining through the proper channel, and he was having lien over the said post of stenographer grade D in the CBI, he was given pay protection upon joining the post join a post of stenographer grade 1 in the Guwahati High Court, as per the which was calculated and as per the last pay certificate issued by the competent authority of the CBI. The petitioner has been shown to have been granted a payment at the rate of 12660 and the grade pay of rupees 42, grade pay at the rate of 4200. And as such, his pay was to be fixed at as such at a time the last pay he was enjoying was
16,860.
860.
860.
Full stop. Since the said pay scale was higher than the basics, maximum basic amount fixed for the said post of stenographer in the Guwahati High Court, that is at 11,825, he became entitled to get that basic pay of rupees, the maximum basic pay of rupees 11,825 upon joining the service in Guwahati High Court in terms of Rule 22/22C of the fundamental rules. It has been submitted accordingly. It is submitted as far as the entitlement of the petitioner to the aforesaid pay scale of 11,825 on joining the service in Guwahati High Court. There is no dispute. There is no dispute as far as that.
No dispute.
Full stop. However, according to the petitioner, while the petitioner was enjoying the said salary on the basis of the pay scale of rupees 11,825, to his dismay, he found on the basis of certain. Next para. It has been. It is a case of the petitioner that subsequent to the adoption of the sixth pay commission. It may be mentioned that it may be mentioned that the last pay enjoyed by the petitioner while serving in the CBI, in which he was given the pay band of rupees 12660 and the grade pay at of 4200 was on the basis of the revision upon implementation of sixth pay commission.
Central six.
A central sixth pay commission. Full stop.
Six central pay.
Sixth central pay commission. Full stop. Next paragraph. It has been submitted after the petitioner joined service in the Guwahati High Court and was given the aforesaid pay scale of 11825 as mentioned above. There was a revision of pay also in respect of the employees of the Guwahati High Court upon implementation of the, what is that?
Assam Services Revision of Pay Rules 2008.
2008. Full stop. According to petitioner, since the petitioner was already enjoying the pay scale of rupees 11,825, upon revision in terms of the Assam Revision of Pay ROP 2010, his pay scale would stand revised to 27,900 on the basis of the table fitment table -22 as prescribed by the authorities. As per the aforesaid fitment table, those who are getting basic pay in the pre-revised scale of rupees 11,825 would the same would be revised to 2200, and that a grade pay of 5900, which the petitioner was earlier enjoying, would be revised to basic grade pay would remain the same. Okay, and accordingly, upon revision of the pay scale along with the grade pay, the revised total pay of the petitioner would be 27,900. In fact, that is how it was calculated and communicated to the petitioner, as can be seen from the
Page 52.
as can be seen from the pay fixation made by the competent authority of the Guwahati High Court. Thus, the petitioner was enjoying the basic pay scale of rupees 27,2900 as communicated by the authority on 24/3/2010. Yeah. Full stop. It has been submitted next paragraph. While the petitioner was enjoying the said pay scale on the basis of the revised pay scale of 27, while the petitioner was enjoying the salary in terms of the revised pay scale of rupees 27,900 as communicated, as fixed and determined by the High Court, as communicated to him on 24/3/2010, it appears there was certain complaint against his pay from some quarters. What is that? What is it?
But
what is that? Page.
the complaint, my lord, is my lord, page 62.
Page 62. Page 62. There's some complaint, and which led to and seeking for refixation of the pay scale of the petitioner, and also on the forceful and also refixation and also refixation on the ground that the petitioner had been getting double benefit of revision of the sixth pay commission, central pay sixth pay commission, as well as the revision by the state of government of Assam, which was applied to the employees of the state the High Court under Assam Revised Pay Rules 2010. It is the case of the petitioner that the said representation submitted by some of the such representation submitted against as such representation for revision of pay was duly considered by the registry of this court, registry of the court, and registry of the court is contained in the report the registrar vigilance dated 15/5/2013. In the said in the said in the note prepared by the registrar, it has been clearly mentioned that the petitioner, after joining this High Court service on 9/1/2009, was granted pay protection on the basis of last pay certificate issued by his parent department and parent department by invoking the provisions of FR 22/22C, and as per law, he is entitled to the aforesaid pay protection. Full stop. The note also indicates that in a similar issue arising out of certain employees of the Guwahati High Court, namely Nandeshwar Kolita, the issue was looked into. The issue was considered in the light of the direction of the Accountant General in holding that the said Nandeshwar Kolita was not entitled to pay protection which was given to him in respect to by giving the last pay which he was enjoying before he joined the service in Guwahati High Court while he was serving in Arunachal in the state of Mizoram.
Nandeshwar Kolita, many employees.
Nandeshwar and others.
Yes.
Nandeshwar who were working earlier with higher pay scale. And accordingly, it was noted that the contention of the Accountant General for denying the pay protection was rejected by the court in WPC number 2674/2012 within bracket DS Dotto versus Registrar General others, which was decided in the writ appeal number 91/2013 by order dated 22/4/2013. Full stop. Under the circumstances, the registrar made the following note. Accordingly, the Registrar General also put up the note before the Honorable Chief Justice of the Guwahati High Court with the following observation. Page 70. You quote it, is quoted below. It may be mentioned that Swenso. Pencil mark, it may be mentioned that while fixing the page Swenso. According to the petitioner, the registry of this High Court never suggested that the petitioner would not be entitled to pay protection. In fact, it stated the note would clearly indicate that the petitioner would be entitled to pay protection, in which event he would continue to draw the salary of salary based on the pay scale of rupees 11,825. It has been submitted that by Mr. It has been submitted by Mr. Nair, P. Nair Council for the petition. If that is so, upon revision of the pay scale in terms of Assam revised pay within bracket pay rules 2010, as per the fitment
table 22.
Table to do, he will be entitled to the revised pay of rupees 27,900. Under the circumstances, the question of fixing any pay scale below the said 27,900 does not arise, and as such, the communication received from the Finance Department as well, and which is sought to be applied by the Guwahati High Court by the impugn communication, which is contrary to the observation of the Honorable Chief Justice would be illegal. Uska pehle likhna. Pursuant to the note submitted by the Registrar Vigilance, the Honorable Chief Justice approved the same by making the note within court. Yes. Yes. It has been submitted by Mr. P.D. Nair. Under circumstances, it is clear that the Honorable Chief Justice has approved that the petitioner would be entitled to pay protection. If that is so, he would be entitled to the revised pay in terms of the protected pay scale, that is 11,825.
As revised.
And upon revision, the petitioner would be entitled to 27,900 as mentioned above. Next paragraph. It has been submitted that, however, the aforesaid the impugn communication from the state stating that the petitioner would be entitled to,
Beg apology.
no, petitioner would be entitled to, what is that government pay,
My lord,
that communication,
my lord,
government's communication,
my lord, page 78.
page 78.
Right.
And I said, it is submitted that the communication of the government that the petitioner pay has to be fixed at 19,070 is without any basis. Inasmuch as if the aforesaid revised pay scale will be 19070, it will presume it will be if the petitioner is to be given 19070 as proposed by the finance department, the same figure can be arrived at if the unrevised pay would be treated as 170.
My lord, below 7,100. My lord, below serial number 8 in page 77 of the fitment table.
Okay, 190. It would be that it would be the unrevised pay scale of the petitioner would be between 6850 and the 7100. It's serial number 7 and 8 of the fitment table.
As on 9 January.
As on 9 January.
9 January.
9 January
2009.
2009. But as mentioned above, the petitioner was allowed to draw the was allowed to draw salary on the protected pay scale of rupees 11,825 as mentioned above. And as said, it has been submitted the proposal by the finance department expressai a contrary to record and also law, and the same cannot be acted upon. But unfortunately, the registry of this court, in contrary to the approval given by the Honorable Chief Justice of the High Court on वो पहले वाला भी तारीख दे देना, it was approved by the yes जो है ना, page
page 70
on 15/5/2013 has proceeded to fix the pay scale at rupees 19070 and also seeking to recover the aforesaid amount of 10,10,72,086 contrary law. It has been submitted that the petitioner having allowed to draw salary on the protected revised pay of a protected pay scale of 11825, which would stand revised to 27,900 upon application of the revision of Assam revision of pay within rules 2010, fixation at the rate of 190 is not permissible. It is lesser than the amount, which is not permissible in law. It has been also submitted that the said refixation at 19070 by the authorities is not only contrary to law, but also has been done without giving any notice and also without explaining as to why the same has been given. Further, the proposal to recover is also cannot be sustained in which is the fixation of the pay scale of the petitioner upon joining the service of the Guwahati High Court was as per rules, and the petitioner had not made any misrepresentation of facts which would lead to drawal of any excess amount. To stop. Under the circumstances, it has been submitted that the aforesaid acts of the finance department as well as the Guwahati High Court deserves to be interfered with. Full stop. Next para. In support of his claim that the issue relating to protection of pay in respect of employees who joined the Guwahati High Court and who were earlier serving in other establishments enjoying higher pay scale, the same has been considered by this court in
2002 Nandeshwar
Kolita
and others versus registrar
reported so has been which was decided on so. In the aforesaid case, is it reported or just
reported?
Reported in so, huh? In the said para number
Para 20 and 22.
In the said decision, this honorable court made the following observation in the following observation in para 20 and 23 as follows.
22.
20,
22. 20 and 22. If
20
Lordship sees my index, my lord. The
No,
first
no,
page of my.
no. This is Dibyendu Shekhar, no?
Dibyendu 17, 20, 23, 26 and 27.
इसमें only type this 20 and 23. There will be
Oh,
sufficient.
sorry, my lord. Oh, correction to that.
Yeah,
I'm sorry,
20
mother. I'll put in the
20,
paragraph.
23, 26,
And
26 and 27. It has been submitted that it is clear that in the aforesaid case of Dibyendu,
My.
Dibyendu
Shekhar.
Shekhar Datta, this court had considered similar situation where the aforesaid Dibyendu who was working in the
Government of
earlier
Mizoram.
working in the government of Mizoram was enjoying a higher pay scale as the government of Mizoram was following the central pay had adopted the fourth central pay commission, and after his service in the Guwahati High Court, his pay was protected and subsequently upon adoption of the fourth Assam Pay Commission, resulting in the revision of pay scale, his revision was sought to be challenged, which was repelled by this court on the ground that firstly, it was already approved. His revised pay scale upon adoption of the fourth Assam Pay Commission was already approved by the Chief Justice of Honorable High Court, and the such decision of the Chief Justice was in exercise of Article 229, and as such a decision could not have been superseded by any government order. Full stop. Full stop. It has been submitted in the present case. The situation is similar in as much as the petitioner was earlier working in the CBI with higher pay scale, and his pay was protected after joining the service in the Guwahati High Court as mentioned above, and consequently, if there is a revision which has been revision of pay scale which has been implemented in the Guwahati High Court by adopting Assam Revision of Pay Rules 2010, the revision of the pay scale, corresponding revision of the pay scale of the petitioner, corresponding revision of the protected pay scale of the petitioner cannot be denied.
Protected pay.
Protected pay cannot be denied. In the present case, the petitioner, on the basis of the revision of pay, of the pay would be entitled to
27,992.
And as such,
900.
and under no circumstances the revision could have been reduced to, the pay scale would be reduced to 19,070 as sought to be done by the finance department as well as the and sought to be implemented by this High Court. It has been further submitted that there is no rational or any legal basis for refixing the pay scale of the petitioner at 19,070 as sought to be done by the authorities. So coming to the submission that since the petitioner has submitted, since the petitioner has not contributed, has not played any fraud or misrepresentation for enjoying the aforesaid pay scale of rupees
27,990.
And since the said was fixed by the authorities themselves, under no circumstances the said alleged overdrawal of salary cannot be recovered, even if assuming that the petitioner may be found ultimately to get the revised refixed at 19,07. In this connection, Mr. PD Nair has relied on the following decision 1, 2, 3, 4. सबको लिख लेना. That is your case.
No, that is.
Yes.
My lord, there's.
Yes, 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 please.
My lord, my date of joining may be.
Okay, okay. So शुरू में लिखना है, then after that he joined upon being selected and the successful, लिखा है ना ऊपर में, successful, he was offered appointment and he joined the service on 9/1/2009.
2009.
So this is the,
That is
these are basic facts, no, submission also,
my
I
lord.
have recorded, yes.
My-
Yes, Mr. Das, what do you say? You tell us how his number one, please one by one, before you start. Number one, is he entitled to pay protection?
Yes,
What is the pay, what will be the pay if his pay is protected?
16, this, last pay,
Last pay is how much?
16,860.
And then plus
Lordship.
the 16,860.
That pay- that
Then if
pay-
that is so, then he will be upon entering service in the Guwahati High Court, how much, what is the pay scale he will be entitled to?
That is the crux, my lord.
What will that, yes,
That
that-
is the crux.
okay. According to you, he will be entitled to 11,825.
He will not be entitled to, I am not on that, my lord.
Then,
Our duty is to protect his 16,860. Our duty is to protect his last pay, that is 16,860.
but you can't give the 16,860 because that pay, you don't have
That has
that
to-
pay.
That 16, how this pay protection will be given,
Acha, acha.
that is provided, my lord.
Okay, okay.
The presentation.
According to
made by
you,
the
that
petitioner-
according
have
to,
protected
okay, very well. According to Mr. Nair, protecting pay scale means you have to give the last, the maximum scale provided under the advertised post, under the post which has been advertised, according to him. It is 11,825. That's what he's saying. So I am, and he has been given. You haven't given. Now, how do you protect the pay scale of Mr. Roy?
Lord,
How do you protect?
yes,
Because you say the last pay, you don't deny the last pay.
my lord, if your lordships
Yes, yes.
kindly see the
Yes, yes, this
my
one.
list of dates that I
Yes.
have given,
Yes,
I have given the pay fixation,
yes.
page 4. Yes.
1990. You got a copy? Oh, I have got two, maybe you have given. No?
Maybe that's why.
That is why there is a dearth of copy there.
I got 4 copies, Miller done, I was just. My ready-made answer will be this, my lord. No
Yes.
doubt, I'll take your lordships with the entire facts.
Ah.
Lordship will kindly see page 4, my lord.
Yes,
On 28/6/1990, he was in a pay scale of 1,200 to 2040. This is
Okay.
in CBI.
okay,
Then on June 2002, he got ACP benefits,
yes,
that is 5,500 to 9,000.
yes,
Then on 1/1/2006, the CCS revised pay rule 2008 implemented. This is
Yes.
in CBI.
yes,
Pre-revised pay scale of 9,300, 34,800 with grade pay of 4,200. This was Millard, he was getting in CBI.
yes,
Now, pre-revised basic pay lordship will skip. On 9/1/2009, join High Court as steno in the pay scale of 11,825,
yes.
5725-11,825. On 19/1/2009, the last pay certificate determining pay as rupees 16,860. There is no doubt about it that his last pay was 16,860. Now, we are required to protect this 16,860.
No, what do you mean protect?
No, as far as the Millard, when he came from CBI.
You are not to protect his, you are to protect his scale in the CBI, not the scale he gets in the after revision.
No, Millard,
You protect means what? His last pay has to be protected.
last pay.
Last pay means what was he getting when he was in CBI?
Millard, this, as per the last pay certificate issued by the CBI, 19/1/2009 is the date of the last pay certificate.
Yes, let us see page.
Page, my lord will find.
Page 46.
Page 47, I think.
P5.
46.
46.
What is to be protected is the see 12660 plus 4200, isn't it?
My lord.
12660 plus
My lord.
4260.
Yes, plus
4200. So that comes to 06861. Yes, this 1680 has to be protected.
This has to be protected.
Yes, correct.
Then my lord will come.
Yes. Therefore, last pay of peace has to be
Yes.
protected. Okay, very well.
Then on 22/1/2010,
Yes,
the Assam ROP rule 2008 came with effect from 1/1/2006.
yes.
Now, in between those things happens, my lord, happened that in the pre-revised space, because in between there was no, my lord, this ROP rule 2010 was not implemented in High Court as well as in the state of Assam. So some interim arrangement had to be made, and he was given the highest in the pre-revised pay scale in between this period. Then when this pre-revised ROP rule was implemented,
That
and
means
this-
11825 was given to him,
yes,
isn't it?
my lord,
Huh?
that was given to him.
Whatever, it's according to it
Yes.
is a very temporary or measurement,
Temporary
temporary measure by whereby he was given 11825.
pending finalized.
Upon finalization.
Now, therefore, his pay, that is 16,860, was protected and fixed at the pay scale of pay of rupees 19,070. That is 13,170 plus grade pay 5,900 in the new post in the pay band of rupees 12,000, 40,000. Now, the question that my lord, from the very beginning that has arises is where from this 19,070 comes?
Yes.
Lordship also, my lord,
Yes.
during the discussion.
He also said there is no, such- it is a by,
Now, Lordship,
yes.
see the fixation in the new post.
Yes,
Last pay as per LPC to be protected is 16,860. That
Yes.
is 12,660 plus 4,200.
yes.
Then 3% of 16,860.
Why 3%?
That is the question, my lord. My
Why
lord,
you bring
the-
this
my
3%?
lord, there are circulars of.
Last pay as per to be protected is 16.
Yes,
30%, 3% you add,
Because as per
you
the-
add. So you add,
yes,
okay, so 13.
yes.
So
505
rounding up to 1370.
Yes,
13170.
rounded off.
Rounded
Then
up.
this 13170 has to be added with the new grade pay. Revised grade pay, then this 19,070. That's how it comes, my lord.
Now, question is one thing. Have you, this new calculation, have you stated in your affidavit earlier? No.
No.
Or is it coming for the first time?
This is, my lord, we have stated in the affidavit.
I don't know, because
we
then
have done-
Mr. Nair has to respond to this. I don't know, because these are all
Yes, Lord.
how the method of calculation. Then what do you like to say? Because this is, if it is coming for the first time, what do you like to do? Tell us.
My lord, if it is for the first time, they are trying to bring certain things on.
Whatever it
My
is,
lord, this
whatever it is.
Nothing
My
new.
lord, this is not permissible. I
Okay,
respond to that, number one.
okay.
Secondly, my lord, these were not there. My lord knows Commissioner of Police Bombay, Gordon Das Bhanji.
No, but then Mr. Nair.
My-
Suppose they have been wrongly calculated 1 plus 1 is equal to 4. No, 1 plus 1 is not 4, 1 plus 1 is 2.
My-
So
My lord,
correcting is not a, because that is
Yes,
okay, but because they are not bringing any new principle.
no, my lord, here they are wrong. Because here what they are on, my learned friend's submission.
Now, what
is-
I am trying to say, Mr., no problem. You have to show that this is absolutely not only new, but is not permissible.
It's both, my lord.
Permissible, not legally permissible not to bring, but legally it is not, this,
Yes, my lord.
this kind of calculation is not at all permissible.
Not at all, not at all, my lord.
That you have to,
That is, it's there, my lord. It's not at all.
Okay.
Because, my lord, the simple
no,
reason.
no, that of course we'll hear you,
My-
but let him say, now that you have got this, then what do you do? Tomorrow or day after tomorrow, or what you tell us?
Tomorrow,
As per your lordships and my
Oh,
serious
tomorrow?
convenience.
Oh, let us do day after tomorrow, because
My-
tomorrow is a hearing, criminal
My-
case, some death reference.
my lord, day after tomorrow.
I would have continued just now, but question is, Mr. Das had produced this, because it appears it is not in
I
record.
have given the breakup here, but
Ah.
the contention is from the very beginning, that is 19,070.
Okay, very well.
In the various communications given by the deputy secretary.
But then how you come to 19,070, that you have not explained. There you are explaining only just now.
That I'm explaining for understanding of your lordships, but
19.
But then you have to make him understand also, because if he understand, he may say, I am withdrawing my application.
No,
Ah,
my lord.
ah,
That
if
would
he
be
understand,
wrong.
if you are able to make Mr. Nair understand, Nair will say, oh, yes, Das is correct, so I am withdrawing my petition.
I
Ah,
don't
but
think so.
subject to his acceptance.
He's a fighter.
If he says, no, I don't accept it, then of course he will continue. But you have to make him also understand, no?
This is for your lordships and my friends' understanding.
We will
Otherwise,
continue because 3:30 there is some interview.
My,
Okay, hearing will continue. हाँ, Mr. हाँ, करके ना?
witness.
हाँ, Mr. हाँ, लाने का हुआ, also Mr.